etc., friends, know that they are not to record this. The Bar Association may take screenshots, and you're aware of that and have agreed to it during this proceeding. See here. You are aware that as far as all participants, attorney participants, that no recesses are allowed unless there is a health emergency. And if there is a problem, please let us know. I passed out cold in a trial once as a trial lawyer, so health emergencies are no laughing matter. If you have a problem, let us know. Otherwise, we will be proceeding without any breaks other than brief pauses after the total examination of a witness so that the scoring jurors can catch up. I'm going to ask each of our scoring panelists now to introduce themselves and with a brief statement of what their background is, and then ask them to state if they have any conflicts now seeing all of your names. Ms. Young, if you'd introduce yourself first.
Hi, I'm Brenda Young, and I've been a paralegal for over 40 years. Used to work for Jack Berryhill and Bill Brady and several of the older attorneys in Denver. And I have no conflicts whatsoever.
And Ms. Stutz.
Hi guys, I'm Erin Stutz. I'm a legal research attorney for the 18th Judicial District. I've been with the 18th for about 4 years almost, and I do not see any conflicts.
And Magistrate Ryan.
I am Magistrate Echo Ryan. I have been a magistrate for about the last 2 years. Before that, I did civil practice as well as some domestic relations. I do not see any conflicts.
Thank you very much. And our representative to the CBA should know that now and be able to move beyond us because we have no conflicts. I remind the teams and the coaches who are on YouTube that any disputes arising out of the competition must be reported in accordance with the competition rules, whether they are inside or outside of our trial today. As all of you participants, the attorneys are aware, strict time compliance is appropriate in this case. If you do go over your time allotted, the timekeepers will notify us of that, and the jurors may make of that what they wish. As far as if they wish to grade you down on that, they may do so. Do we have, for lead counsel for the prosecution, do you have a method in which you would like the timekeepers to notify you as running time? They'll be on the chat line. Do you wish a countdown of, by minutes? Do you wish them just on your examinations just to tell you what time is left if you inquire?
Your Honor, the prosecution would like timekeepers to announce the time every 5 minutes up until there are 5 minutes left, at which point we would request them to update every 1 minute.
Okay, and is that acceptable to the timekeeper?
Yes, Your Honor. Would you repeat that just to make sure that I heard it properly as well, Mr. Howe?
Yes, we request that time be announced every 5 minutes until there are 5 minutes left, at which point we request at 1 minute intervals.
Thank you. And for lead counsel for the defense?
The same will do, Your Honor. Thank you.
And is that acceptable to timekeeper for the prosecution?
Yes, Your Honor.
Great, thank you very much. Let's see here. I have to skip some of these rules because they don't apply to us virtually. I'm going to ask lead counsel for the prosecution to introduce him or herself, and then have each other attorney introduce him or herself for the prosecution.
Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Abbott Howe. I will be conducting the opening statement, the direct examination of Kyle Kuzak, and the cross-examination of Blake Van Owen. May my co-counsel now introduce themselves?
Yes, they may.
Good evening, Your Honor, opposing counsel, members of the jury. My name is Heidi Haverkamp, and I will be conducting the direct examination of Detective Jordan Markowitz, the cross-examination of Taylor Perkins, as well as the closing arguments.
Good evening, Your Honor, opposing counsel, members of the jury. My name is Taylor Cipra, and I will be performing the direct examination of Alex Cifuentes and the cross-examination of Avery Becker. Now may our witnesses introduce themselves, Your Honor?
Yes, they may. And plaintiff's first witness.
Good evening, Your Honor, opposing counsel, and members of the jury. My name is Lily McGovern, and I am Detective Jordan Markowitz.
Good evening, Your Honor, opposing counsel, and members of the jury. My name is Juliana Martin, and I am Alex Cifuentes.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Macklin Gifford, and I am Kyle Kuzak.
And now if lead counsel for the defense would introduce him or herself, and we'll proceed through the attorneys and then the witnesses.
Good evening, Your Honor, opposing counsel, and members of the jury. My name is Olivia Moraine, and I will be conducting the direct examination of Blake Van Owen and the cross-examination of Jordan Markowitz. May my co-counsels please introduce themselves?
Good evening, Your Honor. My name is Adele Donda, and I will be conducting the direct examination of Taylor Perkins, the cross-examination of Alex Cifuentes, and the opening statement.
And for our last attorney.
Good evening, Your Honor, opposing counsels, and members of the jury. My name is Audrey Davies, and I will be conducting the direct examination of Avery Becker and the cross-examination of Kyle Kuzak, and I will be conducting the closing argument.
Thank you. And for your witnesses, first witness.
Good evening, Your Honor. My name is Taylor Davis, and today I'm Blake Van Owen.
Good evening, Your Honor. My name is Tommy McKissick, and I am Taylor Perkins.
And hang on just a minute. There we are. I have to search around the screen here. Mr. McKissick, okay. Thank you.
Good evening, Your Honor. My name is Millie Bjork, but tonight I'm Avery Becker.
Here we go. Okay, thank you very much. As far as procedure goes, please feel free on your opening, your closing, and any examination that you make, with the exception of witnesses, any of the attorneys, you may present your argument, your statement, or your examination seated if you wish. You may stand if you wish. That's entirely up to you. You will not be graded down whether you remain seated or standing. It is simply an accommodation because of the virtual nature of this proceeding. Just so you know, most attorneys deal with this seated when it's virtual. In the last 10 months since the pandemic, I had not a single attorney stand up during a virtual hearing. It's up to you. If you would be more comfortable doing that, you certainly may, but you do not have to. You will not be graded on that. Entirely up to you. The witnesses, of course, will remain seated. I'm going to swear you in three groups: team members, attorneys, witnesses, and then scoring panelists. You do not need to stand. All you need to do is raise your right hand. First, the six attorneys, please raise your right hands. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? And you can nod your head because your microphones are not on. Thank you. Next, the six witnesses, if you would raise your right hands. Do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition? Good. Finally, and scoring panelists, if you would raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
I do.
Thank you. All right, now a few other procedural matters, because we do want to move this quickly, and because in fact, it will not make any difference in the scoring for the jurors for your team. The way we're going to handle exhibits is this, if it's acceptable to both sides, and I'll ask lead attorneys to respond. As far as presenting an exhibit which has not been stipulated for admission, you may first ask to introduce an exhibit and then lay a foundation for it. To speed things up, I'm going to ask you if you wish to have the exhibit reviewed by the witness, put it on the screen. Even though the jury will see it, I will not admit that exhibit unless you lay a proper foundation for it. I just found that in the last trial, excuse me, in the last trial, there was quite a delay in having your co-counsel screen share later on. So if you want to put it up, and we'll lay a foundation for it while it's on the screen, and then you may continue with your examination. If it's an exhibit that's already stipulated, or if you don't want to have it admitted to the jury, if you just wanted to have it admitted into evidence, well, you don't have to screen share it. I do have all the exhibits here in front of me. So if you want me to lay I just don't want to have any objections that an exhibit has come up on the screen before it has been admitted into evidence. There's just no point in it. And we do want to move this as quickly as we can. And it will not have any effect on the jury because, as you know, they are judging on your technique and your procedure, not on the evidence itself. So we will follow the proper procedure, introducing an exhibit, laying a foundation, unless it is stipulated. I will rule on whether it will come in. If there's an objection, I'll rule on the objection, and then we'll proceed with screen sharing if you wish. So with all of that said, are there any issues on the prosecution side that you wish me to rule on prior to opening statements?
Your Honor, we have a few preliminary matters to address.
Go ahead.
We would like that stipulated facts be constructively read into evidence.
That's granted.
We would also like to confirm with Your Honor and the jury that they have a copy with the trial roster, and if not, our timekeeper can put it in the chat for you.
I do not have one. I don't think our jurors have it because I don't have it. It would have had to been emailed to us, and that was too cumbersome. So we don't have it, but what I will be doing, as I said, before each section, I will have each attorney identify him or herself as well as witnesses, so there will be no confusion as to who is being graded. So I do understand we do not have those trial rosters, but we will work without them.
We would also ask that if our attorneys or witnesses are to run into any technical difficulties, that time be stopped to allow for the difficulty to be fixed.
Absolutely.
And also, we request that any time remaining from closing arguments be allowed to use for rebuttal.
Yes, that will be the same for both sides. Closing argument is including the entire period of time, includes closing and rebuttal, yes. And you can bleed over if you do not use all of your primary closing, you can bleed it over into prosecution rebuttal.
Yes, Your Honor.
Anything else?
No, Your Honor.
Okay, for Ms. Moraine, correct? For lead counsel for defendant, anything you would like to add?
Nothing we would like to add, Your Honor, but the defense respectfully requests the same permissions that you have granted to the prosecution.
Absolutely.
Thank you.
Okay, we are now going to proceed with opening statement for the prosecution. Mr. Howe, I believe.
Yes, Your Honor. May I begin?
Yes, you may. Sorry.
We have all had a moment in our lives.
Mr. Howe, before you begin, just take a breath. One thing I forgot, and I apologize just from the experience in the last trial. Before we begin, when we get to examination, here's how we're going to do it. Counsel doing direct, whether it's prosecution or defense, will have both their camera and their microphone on, obviously, as will the witness. During the entire examination, opposing counsel, who will be cross-examining, whichever side it is, will also have camera on and microphone on. We had no problem with background noise, so I don't expect there'll be any problem with this trial either. But that way, it'll be the closest approximation of a trial where you don't have to fumble around to, activate your camera, activate your microphone to make an objection. So during examination, I should have 3 people on my screen, including myself, 2 attorneys, and a witness. So with that said, Mr. Howe, sorry for interrupting you. You may proceed.
We have all had a moment in our lives when we made a choice, yet we didn't choose the consequences. For example, these past few years during Colorado fire bans, people have made the choice to start fires. And when a spark gets out of control, the result is a raging forest fire. It doesn't matter what we intend at the start. We are still responsible for the outcome. And that is what this case is all about. When on March 6th, 2020, in the state of Colorado, Avery Becker broke into the home of her own mock trial coach and murdered him. In this case, the burden of proof rests on the prosecution. And to meet this burden, you are going to hear the testimony of witnesses that visited the crime scene. And unfortunately, you will see pictures that may upset you. In this case, Avery Becker is being charged with first-degree felony murder. This means that she unlawfully broke into the home of the victim, and that during this crime, the victim died. In this case specifically, Avery Becker broke into the home of Mackenzie Brackman with the intent to commit criminal mischief, thereby committing second-degree burglary, and then caused the death of Mackenzie Brackman by stabbing him in the back. How do we know that this is the case? The prosecution is going to call 3 witnesses today. The first witness from which you will hear from is Detective Jordan Markowitz. Detective Markowitz is a detective with the Denver Police Department, and she will tell you how she conducted and what she found in her investigation. She will also tell you how Avery Becker had the clear opportunity to commit the crime, and they will prove this by using call detail records. Secondly, Alex Cifuentes will testify. Alex Cifuentes was a mock trial teammate of the defendants, and she is going to show you the clear intent that Miss Becker had to break into the house of Mr. Brackman. And they will prove this to you by showing you text messages that were sent between the two. Finally, for the prosecution, Mr. Kyle Kuzak will testify. Mr. Kuzak is a crime scene reconstruction investigator of 19 years. And he is going to tell you how what's just started as second-degree burglary became the first-degree murder that Miss Becker is being charged with today. While the burden of proof does not lie on the defense in this case, they are still going to call witnesses. The first witness which they are expected to call today is Professor Blake Van Owen. Professor Van Owen is being paid today to try to tell you that the police conducted a rushed investigation, but they have only ever testified for the defense. And while they are telling you the police conducted a rushed investigation, they hardly even conducted an investigation of their own. Additionally, Taylor Perkins is going to testify. Taylor Perkins is the best friend of the defendant. Because of this, they cannot be trusted with what they are going to say, because he would do anything to protect his friend, including lie. And additionally, this evidence of bias is supported by the call detail records that Miss Detective Markowitz is going to show. Finally, we expect the defendant herself to testify. Throughout the testimony of Avery Becker and all of the witnesses on the defense, you have to remember to keep only the objective facts in mind and to discount all of the bias that they present. In this case, after hearing all of the testimony and evidence that is presented, we are confident that you will choose to convict Avery Becker of first-degree murder, because it doesn't matter what you intend at the start. You are still responsible for the outcome. Thank you.
Thank you. We will pause for just a second while the scoring jurors catch up, because that concludes half of the opening statements. And then we will proceed in a moment with opening statement from the defense with Ms. Moraine in just a moment. And Ms. Moraine will have opening statement for the defense.
Would my co-counsel, Ms. Donda, please begin her opening statement?
Oh, I apologize. Ms. And it's pronounced Donda?
Yes.
Ms. Donda, I apologize. Opening statement for the defense.
Yes, Your Honor. May I begin?
Yes, you may.
Alex Cifuentes had a dream and a plan. Alex spent hours preparing for mock trial, perfecting crosses and directs, and rereading and analyzing the case year after year. But Alex was still no match to Avery Becker. Avery was quick on her feet, intelligent, and a natural mock trial star. The only way Alex could stop Avery Becker would be to lock her behind bars. Members of the jury, this is a case about jealousy, a case about rivalry, and a case about a school dispute between Alex Cifuentes and Avery Becker taken too far. Alex Cifuentes convinced Alex's friend Blair Rollins to work together to first murder Mackenzie Brackman in cold blood and then to frame Avery Becker for their malicious crime. Alex wanted to get Avery out of the way so that Alex could be a mock trial star, while Blair Rollins wanted to avenge Blair's father's incarceration. The burden in this case is on the prosecution. The prosecution must prove beyond a reasonable doubt that Avery Becker committed first-degree murder or second-degree burglary. As you listen to the evidence presented today, ask yourself 3 questions. First, how reliable was the murder investigation in this case? Second, where was Avery Becker on the day of Mackenzie Brackman's murder? And third, are there other suspects who might have had a motive and plan to kill Mackenzie Brackman? To answer these questions, the defense will provide 3 witnesses: Blake Van Owen, Taylor Perkins, and Avery Becker. You will first hear from Blake Van Owen, a private investigator who reviewed the police investigation. She will explain that the prosecution's homicide detective, Jordan Markowitz, conducted a rushed investigation and never even considered other possible suspects in this case. Ms. Van Owen will explain the many deficiencies in the detective's investigation, the conclusions about the murder weapon, and the conclusions about cell tower data and Avery Becker's phone. You will next hear from Taylor Perkins, the defendant's best friend. Mr. Perkins will testify that he was with Avery Becker all day on the day of Coach Brackman's murder. He will testify that he and Avery were looking for Avery's lost phone and that they were nowhere near Mackenzie Brackman's house. Mr. Perkins will further testify that the last time he saw Avery's phone was when he and Avery were with Alex Cifuentes at the Fry Shack. And finally, Mr. Perkins will explain how jealous Alex was of Avery Becker's natural mock trial abilities. Finally, you will hear from Avery Becker, the defendant. Ms. Becker will testify that Alex was jealous of her mock trial abilities and that she and Alex were never even friends. She will further testify that she was with Taylor Perkins on the day of the murder looking for her lost phone. She will tell you that she never could have sent certain text messages from her phone because she didn't have it with her. And finally, she will explain her belief that Alex Cifuentes took her phone so that Alex and Blair could set it up to look like Avery had gone to damage Coach Brackman's house. After you hear from these witnesses, the evidence presented will demonstrate that the prosecution has failed to show beyond a reasonable doubt that Avery Becker committed this crime. The evidence presented will conclude that there is no physical evidence connecting Avery Becker to the scene of the crime. In fact, the testimony will demonstrate that Avery Becker was not at the scene of the crime, but rather with Taylor Perkins looking for her lost phone. Finally, the evidence will demonstrate that Alex Cifuentes worked with Blair Rollins to frame Avery so that Alex could fulfill Alex's mock trial dreams. Alex Cifuentes had a dream and a plan. A dream to be a mock trial star and a plan to convince Blair Rollins to murder Mackenzie Brackman and frame Avery Becker. Thank you.
Thank you. We'll pause for a moment while the scorekeepers catch up. That's the end of opening statements, and in a moment we will have the first witness for the prosecution. And counsel for the prosecution will have your first witness. And if the attorney will please announce him or herself, we'll move forward.
Good evening, Your Honor. My name is Heidi Haverkamp, and the prosecution calls Detective Jordan Markowitz to the stand.
And if you would introduce your witness first and have him or her state both character name and student name, and then I will swear the witness in. So you may call your witness.
Oh, yes. The prosecution calls Detective Jordan Markowitz to the stand.
And if you would introduce yourself as the witness, both character name and student name.
Of course. Good evening, Your Honor. My name is Lily McGovern, and I'm Detective Jordan Markowitz.
And if you'd raise your right hand, please. Do you solemnly swear or affirm under penalty of law that the testimony you're about to provide today in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
And Ms. Haverkamp, you may proceed.
Good evening, Detective Markowitz. Will you please state your name and spell your last for the record?
Yes, I'm Detective Jordan Markowitz. That's Markowitz.
And Detective Markowitz, what is your current occupation?
My current occupation is a homicide detective with the Denver Police Department.
And how long have you been with the Denver Police Department?
I've been with the Denver Police Department for 13 years, but specifically as a homicide detective for 7.
And do you have any certification that is relevant to this case?
I do.
And where were you certified?
My certification is in cell phone technology and forensic data recovery, and I was certified at the American Academy of Law Enforcement.
Was this an extensive course for the certification?
Yes, very.
Do you use this consistently in your work as a detective?
Yes, it's crucial to my work.
And how many cases would you say you've used it in?
Over 50 cases I've used my experience and skills in.
Your Honor, at this time, the prosecution asks that the court recognize Detective Jordan Markowitz as an expert in cell phone technology, forensic data recovery, and crime scene investigations, as her training, experience, and education have all been demonstrated.
Hang on just a moment. Cell phone tech and what else?
Crime scene investigation
Got
and
it.
forensic data recovery.
Forensic data recovery from cell phones?
Yes.
Got it. Okay, and Ms. Moraine, any objection?
Your Honor, may I please do a voir dire of the witness?
Yes, do you have objections to all of those areas or just some of them?
Just some of them.
Okay, which ones?
I object to Detective Markowitz being qualified in the area of crime scene reconstruction and crime scene analysis. I do
Okay.
not, however, object to Detective Markowitz being qualified in the area of cell phone analysis.
All right, or data recovery.
Correct. Thank you.
Okay, so I will qualify Detective Markowitz in the cell phone areas, and you may proceed with your voir dire on the other crime scene investigation issue.
In your witness statement, you talk about your training and certification in cell phone analysis, correct?
Yes, I do.
But you don't have any certification in the area of crime scene reconstruction, do you?
I'm not being asked as an expert in crime scene reconstruction, but crime scene investigation.
You don't have any certification or training in crime scene analysis either, isn't that right?
I'm not being offered as an expert in crime scene analysis. Crime scene
No.
investigation is what I'm being offered as an expert in.
So no.
I don't quite understand your question.
You don't have any certification or training in the area of crime scene analysis, isn't that right?
Your Honor, my witness is not being entered into the field of crime scene analysis, but rather crime scene investigations.
Understood, but just so that if she should wander into the area of analysis outside of investigation, I will permit the question and the witness may answer.
Thank you.
And if you
Can you
need
ask the question again, counsel?
Sure. You don't have any certification or training in the area of crime scene analysis, correct?
Not that I mentioned, but as you know, detectives and policemen and men and women in general have to undergo a certain measure of training.
So no, you don't have any certification or training, correct?
Not that I mentioned in my statement, no.
Okay. Your Honor, based on the witness's responses and their admission that they do not have a degree in or education in crime scene reconstruction or crime scene analysis, I respectfully request that this witness be limited to giving expert testimony only in the area of cell phone analysis.
And Ms. Heverkamp?
Your Honor, the witness is able to testify to these under 702 as she reaches the criteria under experience, mainly because of her years as a homicide detective.
And Ms. Moraine, last word on it?
Your Honor, the witness doesn't have any certification or training in either of these areas. Rather, her primary experience is that of cell phone analysis, and it's the only type of certification or education that she mentions in her statement.
Thank you. I'm going to permit the testimony by the witness, as I've indicated, into the cell phone analysis and forensic recovery, and as to crime scene investigation. Now, should she wander beyond the procedures and the practices that she employed to gather information, which is the investigation, if she should wander into areas of analysis of that information or any conclusions, there may be a contemporaneous objection that might be made by the defense. But as far as describing what she did, I'm going to allow it because she does have apparently a vast amount of experience in doing such investigation, regardless of the fact if she was trained or had certification or education. Experience will qualify a witness. So objection overruled to that extent. If she wanders into areas of conclusions or analysis, you may renew your objection. Ms. Haverkamp, you may proceed.
Detective Markowitz, how did you first become involved in this case?
I was assigned to this case in March of 2020 to investigate the death of Mackenzie Brackman.
And what did you first see when you arrived at the crime scene?
Once I first arrived at the crime scene, I noticed that the front door to the residence was open along with the front gate, and you could see the victim's body just inside the residence, along with a knife near it.
Detective Markowitz, do you have Exhibit 3 in front of you?
I do.
How do you recognize this exhibit?
This is a photo taken from the crime scene of a close-up of the victim's body, specifically the stab wound.
And was reviewing this image an important part of your investigation?
Yes, it was crucial.
Is this a fair and accurate copy of that image?
Yes, it is.
Your Honor, at this time, may my co-counsel display Exhibit 3?
Excuse me. Ms. Moraine, any objection to Exhibit 3?
No objection, Your Honor.
Exhibit 3 is in evidence. You may publish to the jury if you wish.
May my co-counsel, thank you. Detective Markowitz, can you go into a bit more detail about what Exhibit 3 shows?
Yes, it shows the victim's body from a bird's eye view of the body, with more focus directed around the stab wound, which is in the upper left shoulder area.
Thank you, co-counsel. You can take down the image now. Detective Markowitz, while you were at the crime scene, did you find any sort of signs of struggle?
Yes, I did. One of the dining room chairs was knocked over, along with a broken plate on the floor next to it.
And where did your investigation lead you next?
I followed up on all possible leads, and those leads led me to a student by the name of Alex Fuentes.
And what did you learn from interviewing Alex Fuentes?
That our defendant, Avery Becker, had messaged Alex Fuentes detailing plans to trash Mackenzie Brackman's house when he was away as revenge for being kicked off of the mock trial team earlier.
And did you receive a copy of these messages?
Yes, I did.
Do you have Exhibit 14 in front of you, Detective Markowitz?
Yes, I do.
How do you recognize this exhibit?
This is a copy of the messages I received from Ms. Fuentes.
Is this a fair and accurate copy of those messages?
Yes, it is.
Your Honor, at this time, may my co-counsel display Exhibit 14?
First, we have to admit it. Any objections to Exhibit 14, Ms. Moraine?
No objection, Your Honor.
Exhibit 14 is admitted. You may publish it.
Detective Markowitz, from the messages sent, what did you learn?
I learned of a previous history of violence and vandalism, if you will, detailing where the defendant had taken a permanent marker, a Sharpie, to a prized possession of the victims, his Porsche.
Did you learn anything else from these messages?
Yes, I did. I learned of Avery Becker's plan, if you will, to vandalize Mackenzie Brackman's house while he was away, as seen in the text bubble below.
Could you read out that text bubble by chance?
Yes. Quote, "Well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house," unquote.
Now, Detective Markowitz, what was the next step in your investigation?
The next step in my investigation was obtaining court orders from Detective Markowitz, from Avery Becker's attorney and cell service provider, and cellular data records.
And
My
we can,
co-counsel.
we can take down Exhibit 14, please. Thank you.
Thank you. Detective Markowitz, can you go into a bit more detail about the service providers on Avery Becker's phone?
Yes, call detail records are what I gathered from the service providers, and within call detail records, it leaves a record, if you will, whenever a text or call is sent or received, or yeah.
Did you make any sort of diagrams of the call detail records in this case?
Indeed, I did.
Will you turn your attention to Exhibit 16?
Yes.
How do you recognize this exhibit?
This is the diagram I made showing Avery Becker's, the most likely route that Avery Becker traveled from their home to the home of the victim.
Is this a fair and accurate copy of those?
Yes, it is.
Your Honor, at this time, may my co-counsel screen share Exhibit 16?
Not quite yet. Any objection, Ms. Moraine, to 16?
No objection to 16, Your Honor.
Then 16 is admitted and you may publish.
Detective Markowitz, can you walk us through the path that Avery Becker travels?
Yes. In the top of the map, you will see an arc, a shaded arc. It's red. And up within that is a point that says Avery Becker's home, the home of the defendant. And if you will, the dotted line is the most likely route of travel that along Rock Creek Parkway that we believe the defendant to have took on the way to the victim's house, which is demonstrated in the bottom of the map.
And do the call detail records place Avery Becker at the scene of the crime at a certain time?
Objection, Your Honor, speculation.
I'm sorry, Ms. Haverkamp.
Your Honor, this would not be speculation, as Detective Markowitz has already been entered as an expert in this field, and this is based off of data rather than forming an opinion.
And Ms. Moraine?
Well, the witness has no basis in personal knowledge of where Avery Becker was.
If she's able to,
Ms. Haverkamp?
the witness is able to place Avery Becker's phone, which is the knowledge, which is based off of the data that she's giving this opinion.
All right, I'm going to admit the testimony, but I need for the detective to lay a little more foundation about the conclusion. She can testify to cell phone technology, but so far she hasn't. All she's saying is, here's a map. So how does cell phone technology fit into this? How can she make that conclusion? You're going to have to lay that foundation before I will allow her to indicate the probable route.
Yes, Your Honor. Detective Markowitz, what do the call detail records mean in this case?
The first shaded region seen at the top of the map represents the first ping of Avery Becker's cell phone, which comes in at cell tower 1227-3. The second ping comes down in 119-1, which is the second shaded region of the map. And the last ping comes from the general vicinity of the cell tower that is the victim's home.
So what did the call detail records lead you to believe in this case?
Due to the call detail records in this case showing a very direct and clear path of which the defendant traveled, it is my understanding from the data that Avery Becker was at the scene of the crime during the time of the murder.
Detective Markowitz, do you have an opinion as to who is wearing the mask and hoodie coming through the back door in this case?
Yes, I do.
Is that opinion to a reasonable degree of scientific certainty?
Yes, it is.
Detective Markowitz, what is that opinion?
Judging from the height and build of the intruder as seen in the ring videos that I collected.
Objection, Your Honor.
And the objection is what? I'm sorry.
The witness is referring to evidence that has not yet been admitted.
Ms. Haverkamp, if you can lay a foundation that she is aware of that information, she may testify to it. If not, then she cannot.
Yes, Your Honor. Detective Markowitz, while you were at the crime scene, you noticed the Ring doorbell?
Yes, I did. It was one of the first things that I noticed at the crime scene.
And you collected the data from this doorbell?
Yes, I did. It showed me Ring videos showing the intruder trying to enter the front door, entering the back door. And
what did the Ring videos tell you in this case?
It showed a description of the intruder that is to Avery Becker's general build and height.
Now, Detective Markowitz, do you have an opinion as to whose hand was on the knife that was planted in Mackenzie Brackman's back?
Yes, I do.
Is that opinion to a reasonable degree of scientific certainty?
It is.
Finally, Detective Markowitz, what is that opinion?
Due to the record of previous altercations in history between the defendant and the victim, the cellular data records, and overall the malice, it is my opinion and what the evidence has led me to that it was Avery Becker holding the knife.
No further questions at this time.
Thank you. You may take down the exhibit. Thank you. And we'll pause for just a moment. And then we will have cross-examination by Ms. Moraine. And Ms. Moraine, go right ahead, cross-exam.
Thank you, Your Honor. Good evening. My name is Olivia Moraine, and Detective Markowitz, I'm going to ask you a few questions.
Good
You
evening.
arrived at the scene of the murder and noticed a body just inside the front door, right?
Yes, that's correct.
And after confirming their ID, you recognized this person, didn't you?
Yes, it was Mackenzie Brackman.
And you recognized them because you worked with them before, right?
I wouldn't say work. I've had experiences in the workforce with them. I did not often
So
work
you
with Mackenzie
testified in
Brackman.
trials against his clients, didn't you?
Yes, I did.
And so upon realizing the body was Mackenzie Brackman, you thought it possible that he was killed by a, quote, disgruntled ex-client. Is that right?
Yes, that's correct. But upon further investigation of the evidence, I realized that that was not it.
So you never followed up on this theory, did you?
No, because the evidence led me directly to Avery Becker.
Right. So you instead formed your opinion based on what you deemed the first big break in the case, right?
Yes, that's correct. I follow where the evidence
So I would
leads
like to direct your attention to this first big break. You used forensic software to download the contents of Mackenzie Brackman's phone, right?
Yes, that's correct.
So this technology that has the capacity to download the contents of a cell phone was available to you throughout the course of this investigation, wasn't it?
Yes, it was.
But you didn't use this technology to examine the contents of Alex Cifuentes' phone, did you?
No, I did not, considering that Alex Cifuentes had forgot their phone at home.
Please direct your attention to what's been previously admitted as Exhibit 14. Are you familiar with Exhibit 14?
I am.
And you received these images from Cifuentes following an interview with them, correct?
Yes, that's correct.
But you never saw these text messages directly, did you?
No, I did not.
Because Alex didn't have their phone with them during their interview, did they?
Miss Cifuentes had forgotten their phone due to nerves at the
So
interview.
you accepted these images from Cifuentes a day after your interview, didn't you?
Yes, that's correct.
And you didn't ever actually confirm the validity of these messages, did you?
No, I did not.
But you did use these messages to help you form your opinion about the case, right?
Yes, I did. Alex Cifuentes has showed and will continue not to show any signs of untrustworthiness.
You saw these messages even as the biggest break in the case, didn't you?
One of them, yes.
So you used unverified evidence to form your theory against Avery Becker, didn't you?
Exhibit 14 was one of the many breaks in the case that I used to form my opinion against Avery Becker. I do not follow evidence based on one piece of evidence that I received, but
Yes,
rather a
but
collection
the
of
piece
them.
of evidence that you have confirmed was unverified was used when you formed your theory against Avery Becker, wasn't it?
Objection, Your Honor,
Unverified.
asked and answered.
And not that because of the answers of the detective in equivocating somewhat on what her opinion has been based on, not just one fact, but on many facts, I feel that the question is appropriate to restate, and objections overruled. Ms. Moraine, let's ask it a final time.
So this evidence that you have confirmed was unverified was used to form your theory against Avery Becker, correct?
One of the many things that I used to form my
So,
theory
yeah.
against Avery Becker. Yes.
I would now like to direct your attention to the part of your investigation that focused on the call detail records. You reached out to Avery's attorney to obtain a warrant to search Avery's phone, correct?
Yes, I did.
But this was impossible because you were informed that Becker lost the phone on March 5th, correct?
That is what was said to me, yes.
So while you conducted your analysis, you knew that it was possible that Avery had lost their phone, didn't you?
Possible, but not likely considering the evidence.
Yes, but it's very possible that Avery and her phone are two different things, isn't it?
Well, of course. Do you have your phone attached to you, counsel?
So I would just like to ask one more time. It's very possible that Avery and her phone were two different things, correct?
Not very possible. Well, of course, it is very possible. I apologize.
But you assumed them to be the same entity, didn't you?
Yes, I did.
Even though it's possible that Avery didn't pick up her phone because she didn't have her phone, isn't it?
With my theory of the case, the reason why Miss Becker did not pick up her phone was because she was murdering
Yes,
our witness.
but it is possible that Avery did not pick up the phone because she didn't have the phone, isn't it?
Possible, yes.
Thank you, Your Honor. No further questions.
And we'll pause for just a moment before redirect. And Ms. Haverkamp, you may redirect your witness.
Detective Markowitz, you still believe that those text messages are valid?
Yes, I do.
And you verified those messages yourself?
Yes, they showed no indication of Photoshop.
No further questions at this time.
And Ms. Moraine, recross.
No, Your Honor. Thank you.
Thank you. And Detective, you are dismissed. Or
thank you, Your Honor.
excused, I should say. And we'll wait for just a moment while the scoring jurors catch up before we have the prosecution's second witness. And if we could now have the prosecution's second witness, if examining counsel would introduce herself.
Yes, Your Honor. My name is Taylor Sipra.
And if you would call your witness to the stand, I will inquire of the name and also student name.
Yes, Your Honor. The prosecution calls Alex Cifuentes to the stand.
And Ms. Cifuentes, if you could introduce yourself along with your actual name.
My name is Juliana Martin, and I am Alex Cifuentes.
And Ms. Cifuentes, if you would raise your right hand, do you solemnly swear or affirm under penalty of law that the testimony you're about to provide today in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
And Ms. Sipra, please proceed.
Before I proceed, Your Honor, may I request a time check from the prosecution's timekeeper?
Absolutely.
Thank you. Good
right ahead.
evening. Thank you. Good evening, Ms. Fuentes. My name is Taylor Cipra. Please state your first name and spell your last for the record.
My name is Alex Cifuentes, Sifuentes.
Ms. Fuentes, what is your involvement in today's case?
I am sorry, could you repeat the question?
Yes. What is your involvement in today's case?
I am here on behalf of the prosecution to help. I would bring Avery Becker to justice.
Thank you, Ms. Fuentes. First, let's talk about your high school career. Where do you currently go to high school?
I'm currently a senior at Colorado High School, also known as CHS.
And what activities are you involved in at CHS?
I'm a part of the mock trial club.
What is mock trial, Ms. Fuentes?
It's a really fun club where we're given fake cases and then we get to create our own cross-examinations, directs, opening statements, and closing arguments.
Are any of your mock trial teammates today here in court?
Yes, Avery Becker and Taylor Perkins.
Ms. Fuentes, can you identify the defendant in today's case?
Yes, today Avery was wearing a grayish mock turtleneck with a black blazer.
And if the defendant would activate the video, please. There we go.
Your Honor, let the record reflect that Ms. Fuentes has accurately identified Avery Becker in today's case.
The record so reflects, and the defendant may mute the video.
Thank you, Your Honor. Now, who coached your mock trial team, Ms. Fuentes?
Mr. Brackman coached our team.
Can you tell us a little bit more about your coach, Mr. Brackman?
Of course, he was a great coach. He really cared about us, and his great attorney skills really helped to make our team better.
And can you briefly describe for us a normal team practice?
Yes, so while most of us on the team would be working on our case and how we want to portray it, Avery, of course, would walk in late and completely unprepared.
And how did this affect your team?
It caused us a lot of anxiety because what if we weren't ready in time for regionals?
What did Mr. Brackman do as a result of this?
After a while of this occurring, he had no choice but to demote Avery down to B team.
What happened next?
Next, Taylor Perkins ended up quitting the mock trial team the week before regionals, forcing Mr. Brackman with nowhere left to turn, making him have to bring Avery way back up to A team.
Objection, speculation.
Your Honor, this is Your Honor, answer or response.
Yes, you may.
This is not speculation, Your Honor, as this is based on the witness's rational perception, and she was there at the practice that Avery Becker was voted to B team, as well as the practice that Taylor Perkins quit the A team.
And Ms. Donda.
Your Honor, Ms. Cifuentes cannot accurately testify to Mr. Brackman's personal thoughts and actions, as that would be speculation.
Ms. Cipra?
Response, Your Honor.
Yes.
Pursuant to Rule 701, Alex Fuentes can testify to a rational perception of the fact that Mr. Brackman demoted B team, as she has experienced and understood the reasons for this demotion and why that was made possible.
All right. The jury will be instructed as follows regarding the testimony. The testimony will stand with this exception that Ms. Cifuentes can testify as to what happened, the demotion, as to whether or not the coach was forced to do this. She cannot testify to, because that is the coach's subjective state of mind of being forced to do something. The fact that he did it is admitted. The reason why he did it is not. You may proceed.
Yes, Your Honor. Ms. Fuentes, would you like me to re-ask that question?
Yes, please.
Did Mr. Brackman demote Avery to B team?
Yes, he did.
What happened after that demotion?
After that demotion, Taylor Perkins quit the A team right before regionals, making it so that Avery had to move back up onto A team.
Is that what happened?
Yes.
How was your team at regionals?
We did well. We were able to qualify a spot to go to state.
Were your practices after regionals any different?
Not really, but the tension at practice did increase.
Can you explain that more?
Sure. The meeting right after regionals, Mr. Brackman and Avery got into a really big fight. And it looked like a spark lit up in Avery's mind as she stormed out of practice, infuriated.
What happened when she stormed out of practice?
With a permanent marker, she vandalized Mr. Brackman's Porsche.
Ms. Cifuentes, do you think it's possible that Miss Becker could have mistaken that Sharpie for something else?
No way. We've never used expo markers or anything like that at the board when we're mapping out our cases. We only ever use permanent marker.
Now going back to the car, what happened after Avery Becker walked out of the parking lot?
Like I said, she vandalized Mr. Brackman's Porsche, writing Worst Attorney Award on it.
And what happened next?
Mr. Brackman kicked her off the team for good this time.
How did this affect your team to the best of your knowledge?
It caused a lot of stress because of the mock trial rules. We can't just substitute a new person on our team for state. And so we were kind of in a sticky situation.
Did Avery Becker reach out to you after she'd been kicked off the mock trial team?
Yes, she texted me.
And what did you think about helping her?
I knew I had to do it for the team, but I wasn't necessarily opposed to a larger role on the team.
Were you able to help Miss Becker get back on the team?
I was not. Mr. Brackman had already made up his mind about her.
How did Avery Becker take this news?
Not well. To say that she was frustrated would honestly be an understatement.
Objection, speculation.
And Ms. Cipra?
Response, Your Honor?
Yes.
This is not speculation, as this is Alex Cifuentes' reasonable sense impression from the way that she perceived Miss Becker to have taken that. When I asked the question, I asked, what did you perceive? So I'm asking for Ms. Cifuentes' own perception of it, not exactly what Ms. Becker might have said or thought.
You may ask the question what she perceived, but you did not ask that question. So you may ask that question what she perceived, but that's not the question you asked. So we'll strike that question and have a new one.
Yes, Your Honor. Ms. Cifuentes, would you like me to re-ask the question?
Yes, please.
Ms. Cifuentes, what did you personally interpret from Avery Becker's response to you?
That she was very frustrated.
Ms. Cifuentes, please direct your attention to Exhibit 14. Ms. Cifuentes, what is Exhibit 14?
It's the text conversation between Avery and I.
Your Honor, permission for my co-counsel to screen share Exhibit 14.
Yes,
Previously entered.
Exhibit 14 has been admitted. You may put it up, yes.
May my co-counsel please screen share Exhibit 14?
Absolutely. Any exhibit that's been admitted, you don't have to ask, just put it up.
Yes, Your Honor. Ms. Cifuentes, please read the 7th text message on the first page.
Well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house.
And Ms. Cifuentes, what did you personally interpret that text message to mean?
At first I wasn't positive, so I texted back asking for a clarification. And Avery said that she was going to wait till Mr. Brackman was at work and then trash his house.
Thank you. May my co-counsel please unshare this exhibit?
Yes.
Now, Ms. Cifuentes, at some point, did you learn that your coach was deceased?
I did, yes.
And Ms. Cifuentes, were you contacted by someone working for the government in today's case?
I was contacted by a detective, yes.
What type of contact did you have with the detective?
Objection relevance.
And Ms. Cipra?
Your Honor, this is relevant because this goes to show, this lays further foundation for Exhibit 14, and this goes to also show how those text messages came to be. And yes, Your Honor.
And Ms. Donda?
Your Honor, I stand by my objection.
And which is what exactly?
That it was not.
Why is this objectionable? That's my question.
Well, it was not relevant to the exhibit, and it was not made clear the relevance.
I'm going to allow the question to be answered. I think it does lay some background for this. So objection is overruled. You may re-ask the question, Ms. Cipra.
Yes, Your Honor. Ms. Cifuentes, what type of contact did you have with Detective Markowitz?
The detective asked if I could come in for an interview and show them the text messages I had between Avery.
Now, why did the detective want to talk to you about the text messages?
Because I had told her about them.
Now, Ms. Cifuentes, what happened to the best of your knowledge at this interview?
Well, I was really flustered because my coach had just died, and so I forgot my phone at home on the charger and went to the interview without it.
What happened at the interview?
We talked, and she said that I could send her screenshots of the text message chain.
Were you finally able to provide the detective with those text messages?
I was, yes.
No further questions at this time, Your Honor.
And we'll wait for just a moment before we have cross-examination. And Ms. Donda, cross-examination of this witness.
Yes, Your Honor. Good evening, Ms. Cifuentes. My name is Adele Donda, and I would like to ask you a few questions. You testified that you and Avery were on the mock trial team together at Colorado High School, correct?
Yes, that's correct. She's the one that convinced me to join my freshman year.
And Avery was pretty good at mock trial, wasn't she?
Yes, she was.
And you were pretty good too, weren't you?
Well, yes.
But no matter how hard you tried, Avery was always better than you, wasn't she?
Yes, but she mostly just coasted on her good looks.
And that was frustrating for you that Avery would do so well without trying, wasn't it?
Occasionally, yes.
So you'd admit you were a little jealous of Avery.
Sure.
And in fact, you even said that you thought Coach Brackman should have pressed criminal charges against Avery.
Well, vandalizing is a criminal thing, so yes.
Now, moving on, please direct your attention to previously admitted Exhibit 14. Exhibit 14 is a screenshot you said you took of you took of texts on your phone, correct?
Correct.
When you met with the detective, though, you didn't bring your phone, did you?
Like I said, I found out my coach had died and my phone had been having trouble holding charges, so I was in a rush and stressed, so I forgot it.
So that's a no.
Could you repeat the question?
When you met with the detective, you didn't bring your phone?
No, I didn't.
So instead, you sent screenshots of your phone to the detective, correct?
Yes.
So you're the only one who saw those text messages in Exhibit 14 when they were on your actual phone, correct?
Correct.
And you testified that you don't have your phone anymore, didn't you?
Objection, Your Honor, relevance.
And Ms. Donda?
Your Honor, this goes to the accuracy of Exhibit 14 and the validity.
And Ms. Cipra?
Your Honor, this is not relevant because we are not asking about the phone, just the text messages. And so therefore we don't need, doesn't matter where the phone was at that moment, if the text messages are just in question.
Ms. Donda, last word.
Your Honor, it goes to the validity of the exhibit if Ms. Cifuentes got rid of her phone right after and nobody else saw those text messages.
I'm going to allow the question and have the witness answer. The issue here is not the fact that the exhibit has been admitted and that was what was on the phone when the attorney or when the detective got it. The issue is the credibility of the witness, whether or not it was changed and whether there was an opportunity to change it. So I believe that it is relevant to that issue, the credibility of the witness. So you may proceed. So let's re-ask the question.
So you're the only one who saw the text messages in Exhibit 14 when they were on your actual phone.
Like I said, yes.
And you testified that you don't have your phone anymore, do you?
No, it finally stopped working and I had to replace it.
So you couldn't even show me the text on your phone right now because you conveniently got rid of the phone, correct?
Conveniently got rid of it? No, I had to get a new phone because it just wouldn't work like at all anymore.
But you wouldn't be able to show me the text on your phone right now, correct?
Objection, Your Honor, asked and answered.
Sustained. Move on.
We really can't confirm that Exhibit 14 was an actual screenshot then, can we?
I mean, why would I lie about it?
Okay, so let's assume for a minute that these really are actual screenshots from your phone. Could you look at the top of the screenshot and tell me, is there a time on that screenshot?
No, yes, 15:06.
And that's the time you took the screenshot, right before you sent it to the detective, correct?
Correct.
But there's no time indication on the individual text between you and Avery, is there?
No, for that you'd have to like slide over.
So we really don't know when those texts were sent, do we?
Yes.
And is there a date indicating the day they were sent?
No.
So these texts could have been sent before or after the murder of Mackenzie Brackman, correct?
Correct.
And we also don't know if you created these texts or if Avery sent them then, do we?
I mean, Avery did send them, but I guess that's correct.
Now, moving on, let's go back to the day you saw Avery and Taylor at the Fry Shack after Avery got kicked off the team. You and Avery had a good talk that day, didn't you?
Objection, Your Honor, relevance.
Ms. Donda?
Your Honor, this goes to build foundation for the interaction between Avery and Alex the day before the murder.
Ms. Cipra?
I stand by my objection.
Objection is overruled. It does lay a foundation for, this case has a lot of relationships and this is just one more of them. So I'll allow it. You may re-ask the question.
Thank you, Your Honor. You and Avery had a good talk that day, didn't you?
Yes, we did.
And Avery even let you play a game on her phone, didn't she?
Objection, Your Honor, relevance to why Avery, or why it matters that Alex Fuentes played a game on Avery Becker's phone.
I'm going to roll this into the last objection. We're still laying a foundation for the relationship between the defendant and this witness. You may proceed.
Thank you, Your Honor. I will repeat the question. And Avery even let you play a game on her phone, didn't she?
She did, yes.
So tell me again, you did have Avery's phone that day at the Fry Shack?
For a little bit, I did, yes.
Thank you. I have no further questions.
And we'll pause for just a moment before we have redirect of this witness by Ms. Cipra. And Ms. Cipra, you may redirect.
Yes, Your Honor. Ms. Cifuentes, why were you jealous of Avery?
I mean, she's pretty physically attractive and she has some natural talent.
Now let's talk about the phone. Why didn't you bring your phone to the interview with the detective?
Like I keep saying, my coach had just died and I really looked up to him. So I was pretty flustered about the whole situation and having to go talk to the police about it, that one of my own friends could have done it. And to add on to that, my phone was barely holding a charge. So I just forgot it in all of the chaos.
And Ms. Cifuentes, why did you get rid of your phone?
Like I said earlier, it could barely hold a charge and eventually it just stopped working. So I had to get a new one.
Thank you, Your Honor. No further questions.
And in just a moment, Ms. Nanda, you'll be able to recross if you wish. Just pause for a minute for the scores.
Your Honor, I have no recross.
Fair enough. And Ms. Cifuentes, thank you very much. You are excused. And now we will just briefly pause so the scorers can complete that witness before we have the third witness for the prosecution. And counsel for the prosecution, your third witness. And we have Mr. Howe, and who will you be presenting?
Your Honor, I will be performing the direct examination of Kyle Kuzak.
And Mr. Kuzak, I'll assume you are on the stand. If you would please introduce yourself with both your character and your student name.
Yes, Your Honor. My name is Macklin Gifford, and today I am Kyle Kuzak.
And Mr. Kuzak, would you please raise your right hand? Do you solemnly swear or affirm under penalty of law that the testimony you're about to provide today in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do, Your Honor.
Thank you. Mr. Howe, you may proceed.
Your Honor, before I begin, I would like to request a quick time check. Thank you. Good evening, Mr. Kuzak. Could you please say your first and last name and spell your last name for the record?
Yes, my name is Kyle Kuzak. That's K-U-Z-A-K.
Mr. Kuzak, what do you do for a living?
I've spent the last 19 years as a crime scene reconstruction investigator.
And are you certified in this field?
Yes, I have obtained certification from the Colorado Bureau of Investigation.
And with your crime scene reconstructions, is there any sort of subfield that you consider yourself to specialize in?
Yes, I specialize in complex crime scenes, such as the one from this case.
And Mr. Kuzak, where do you currently work?
I've spent the last 3 years as a civilian employee for the Denver Police Department, investigating complex crime scenes.
And in your work as a complex crime scene reconstruction investigator, is there any sort of specialized knowledge or techniques that you bring to your investigations?
Yes, I approach every investigation with 2 key principles. The first is that I assume every case is going to trial, and then I conduct a fair and complete investigation in accordance. The second is that I will always memorialize, document, and organize all evidence with a future mindset of reconstruction.
Your Honor, at this time, the prosecution moves to enter Kyle Kuzak as an expert in the field of crime scene reconstruction, specifically of complex crime scenes, as he has shown sufficient experience, knowledge, and skill in the field.
And The specific statement that was made was about crime scene investigation. Would you ask the witness if that includes reconstruction as well as investigation?
Mr. Kuzak, does crime scene investigation include crime scene reconstruction?
Yes, for every case, I reconstruct and then investigate the crime scene.
Okay, assuming that investigation includes reconstruction, Ms. Davies, any objection to qualifying the witness?
Yes, Your Honor. May I please complete a voir dire?
Yes, you may.
Thank you. Mr. Kuzak, you are not a police officer, isn't that correct?
I'm not a sworn officer. I'm a civilian for the Denver Police Department.
So you only have a certification in crime reconstruction?
Crime scene reconstruction counselor. Yes, I do.
And you don't have a degree in crime scene reconstruction?
I have certification. I do not provide a college degree, though.
So essentially, you didn't go to school for this job?
Not everyone goes to school for the job that they want to pursue with their life. That's the point of certification, so that you don't have to achieve a degree in a certain field.
So is that a no?
I did not go to school, but I did commit training and get a certification for this field.
Thank you. Regarding the specific case, you didn't arrive at the crime scene first, isn't that right?
Correct. I arrived after other members of my crime lab had already visited the scene.
So others processed the crime scene before you even got there?
Objection, Your Honor. These questions are not relating to the qualifications of the expert in the field.
Ms. Davies.
These questions are relating to the qualifications and the credibility of this expert witness in how he is related to the case and his process in completing this case and the crime reconstruction.
I'm going to sustain the objection because whether or not he followed the proper procedure, the accuracy of the evidence he looked at, meaning had it been already disruptive, would go to his credibility of his opinion as opposed to his ability to give an opinion. And that's all I'm doing in qualifying is his ability to do it. So let's move to a different question. I sustain that one.
Okay, thank you. I'll move on. Your Honor, based on the witness's response and their admission that they do not have a degree or education in crime scene reconstruction, they should not be qualified as an expert in crime reconstruction in this particular case.
Mr. Howe.
Your Honor, pursuant to Rule 702, the witness need only provide sufficient one of these categories, and Mr. Kuzak has provided clear, sufficient experience to be qualified as an expert in crime scene reconstruction.
Ms. Davies, last word.
I stand by my objection. He does not have a degree in crime reconstruction and did not go to school for this job.
I will qualify Mr. Kuzak as an expert in crime scene investigation, which includes, according to his testimony, crime scene reconstruction. He is certified by the CBI, meaning he does have some qualification in that sense, but he also has quite a bit of experience. And in addition to education and training, experience alone can qualify a witness as an expert as long as that experience is relevant and extensive enough. I find that it is. So the objection is overruled. Mr. Howe, you may proceed with this witness.
Your Honor. Mr. Kuzak, with the principles that you just mentioned in mind, how do you normally approach your investigation or reconstruction?
I normally approach all investigations with 5 important steps that allow me to accurately reconstruct and investigate crime scenes. The first is the recognition and documentation, then the collection of evidence, the evaluation of evidence, which is then followed by hypothesis and testing, and the 5th is the reconstruction and the reconstruction report.
For the first part of your investigation, what steps did you take?
For the first part of my investigation, I mainly focused around recognizing evidence and then documenting it for later analysis in my investigation. I used a witness tracking spreadsheet, a physical evidence tracking spreadsheet, and a rudimentary flow chart for this part of my investigation.
How about the second part? What did you do for that?
For the second part of my investigation, I collected all the evidence that I was able to. This was largely because I was able to use a more expanded version of my current existing organizational framework.
Mr. Kuzak, in your collection of evidence, did you ever have a chance to review the ring video footage from the residence?
Yes, I did.
And what did you learn from this footage?
From the footage, I learned that there was a perpetrator matching the same general height and build of the defendant. They approached the house originally at the front, but were unable to enter at the front door, so they went around to the back through a side gate. They were then filmed entering the residence at the back.
Mr. Kuzak, did you ever visit this residence yourself?
Yes, I did.
And what did you find?
I found many things. Upon entry, I understood that there was scuff marks on the floor. I then noticed those and used them as part of my evidence.
What did these scuff marks suggest to you?
Scuff marks can indicate many things. On their own, they possibly could mean nothing. However, when corroborated with other evidence, it more than likely provides the scenario for a struggle.
What other evidence?
There's a broken plate approximately 5 feet from the back door that indicated another possibility of a struggle. Those combined make it overwhelmingly likely that a struggle ensued.
Mr. Kuzak, do you have exhibits 9 and 18?
I do.
Could you please describe what they are?
Yes. Exhibit 9 is a photo of the broken plate from the victim's residence, and Exhibit 18 is a picture of the knife from the crime lab.
Exhibit 18, excuse me.
The scuff marks, sorry.
Thank you. And are these fair and accurate representations of these photos when you viewed them?
Yes, they are.
Your Honor, at this time, the prosecution moves to enter both Exhibit 9 and 18 into evidence as the accuracy has been shown and authenticity has been stipulated to.
And Ms. Davies, any objection to 9, the plate?
Objection on relevance.
Okay, we'll address that in a moment. What about 18?
No objection, Your Honor.
Okay, Exhibit 18 of the scuff marks is admitted. What is your objection that this is not relevant evidence?
The witness did not lay clear, the witness did not lay clear evidence about what this relates to in regards to the case and how these are relevant.
Mr. Howell?
Your Honor, the questions I just asked Mr. Kuzak, he explained to us that the plate with the scuff marks was indicative of a struggle that occurred at the home.
And Ms. Davies?
I stand with my objection. Thank you.
I'll admit 18 is already admitted. I will admit 9. It is at least arguable that a plate could be broken in a scuffle, which could be corroborated by the scuff marks. So 9 and 18 are both in. You may proceed.
Mr. Kuzak, did you find anything else in the kitchen that was of note?
Yes, I found a partially open knife drawer with several smaller knives and other various kitchen utensils. I also noticed a knife block with a missing slot approximately the same size as the one recovered from near the victim.
Mr. Kuzak, what did you do for the third step of your investigation?
For the third step of my investigation, I essentially evaluated my evidence. I saved much of the formal evaluation and testing for a later stage.
How about the fourth step?
For the fourth step, I used Tom Bevel and Ross Gardner's 7-step methodology for event analysis to further understand my case.
And in the fifth step, what did you do?
In the fifth step, I reconstructed the case and created a reconstruction report based off of my findings.
And Mr. Kuzak, did you come to an expert opinion in this case?
Yes, I did.
And what is that opinion?
My expert opinion in this case is that a perpetrator matching the same general height and build of the defendant approached the residence and upon entry had alerted the victim to their presence. The victim then armed themselves and sued the perpetrator in a struggle. At some point, the victim was disarmed, stabbed in the back. They had the lower arch of their thoracic aorta sliced, and they quickly died of exsanguination afterwards.
Thank you. No further questions.
Thank you. And we'll just a moment before we have cross-exam. And Ms. Davies, you may cross-examine this witness.
Thank you, Your Honor. Hello, Kyle Kuzak. My name is Audrey Davies, and I'm going to ask you a few questions, if that's all right.
Good evening, Ms. Davies.
You testified that you are a crime scene reconstruction investigator who investigated this case, correct?
Yes, correct.
But you are not the first investigator on the crime scene, isn't that right?
Correct. I was not the first investigator onto the crime scene.
In fact, you did not arrive on the scene until other investigators had completely processed the entire scene.
I never said they completely processed the entire scene. I said that they had processed part of the scene, and they are also trained in the preservation and documentation of evidence either way.
But either way, you were not the one who processed the scene directly.
I processed a lot of the scene, however, I was not the first person to do so, correct?
Thank you. Since you were not the first person to process the scene, you cannot guarantee that the process was 100% accurate, can you?
I can guarantee that the process was extremely accurate due to the fact that I have received much of the same training that the first people to arrive and start processing the scene were given. That's the reason they were allowed onto the crime scene, counselor.
But it could have not been 100% accurate since you didn't arrive to the crime scene until it had been processed.
It is possible, however, it is extremely unlikely in this field.
Thank you. You mentioned in your witness statement that you would have wanted more evidence. And that evidence you would have wanted includes DNA, fingerprints. Isn't that correct?
Objection, Your Honor.
And the objection is?
Hearsay.
Ms. Davies?
This is in his witness statement, which can be viewed by every person in the trial. So his credibility goes to this witness statement.
And Mr. Howe, why is his opinion, regardless of whether it is in his statement or not, why is his opinion about that hearsay?
Well, Your Honor, I'm referring to the question which asked, you mentioned in your statement, which implies an out-of-court statement made for the truth of the matter asserted.
I'm going to overrule the objection. I consider the question only meaning that this is how counsel knows about this, is that it was in a statement. She's asking the witness to corroborate it. Overruled. You may re-ask the question.
Thank you. You mentioned in your witness statement that you would have wanted more evidence, correct?
Correct. However, that is always the case. It's not specific to this crime scene.
So you would have wanted more DNA, fingerprints, correct?
I would have much preferred to have more DNA and fingerprints. However, that was not the case. The perpetrator is wearing a hood, gloves, and a mask. And contrary to popular belief, DNA and fingerprints are not left on every surface as seen in the movies.
Thank you. And so the fact is that you don't have a single piece of concrete physical evidence, such as DNA and fingerprints, that connect Avery Becker to this specific crime scene, do you?
I do not have physical evidence of her. However, I do have photographic.
So let's address the potential evidence that was destroyed. The pictures of the blood droplets. You mentioned in your witness statement that you saw pictures of blood droplets on the way out of the kitchen towards the hallway, as well as blood splatter on the walls. Isn't that right?
Yes, that is correct.
And you viewed these photos, correct?
Yes, I reviewed them as part of my investigation.
However, just shortly after you viewed these photos, the files were corrupted, right?
Objection, Your Honor.
And the objection is?
Relevance.
Ms. Davies?
This shows the credibility of the witness's testimony regarding what he formulated his 5 steps upon.
Mr. Howe?
Your Honor, Mr. Cusack was not the one who lost these photos, so the attack on credibility would not be towards this witness.
Oh, may I respond, Your Honor?
Yeah, you may have the last word, yes.
Thank you. I'm not going to the fact that his credibility, I'm going to the fact of the photo's credibility. I misspoke. I'm going to the fact of his credibility regarding these photos, since these photos were corrupted and nobody can see them.
Nope, you just get 3. Actually, I'll let you, go ahead. You can have the last word.
Your Honor, these are not relevant to Mr. Cusack's credibility, as he was not the one who lost the photos.
But that's not what the objection is. The objection is to the credibility of the evidence itself. And what the testimony establishes is that if the jury is going to consider blood spatter evidence, it's going to be on the word of this witness as opposed to on photographic evidence. And I will allow that. If the jury believes Mr. Kuzak that that's what he saw, then they will believe that. If they don't, then they won't. But there's no photographic evidence, so I believe that the question is appropriate. Overruled, you may proceed.
Do you want me to ask it the question again?
Yes, please, Counselor.
Okay. However, after you viewed these photos, the files were corrupted. Isn't that right?
The files were corrupted well after I viewed them, and they had no effect on my investigation.
And so nobody, including the jury, can see this evidence today.
Correct. However, I can testify to it.
And so without these pictures, nobody can attest the information that you're claiming is true, can they?
Besides me.
Thank you. Let's discuss the videos that are marked as Exhibit 10. You mentioned in your witness statement that while you were investigating this crime, you watched the Ring camera videos, right?
Yes, I did.
And in these videos, you actually can't see the perpetrator's skin color or face, can you?
No, you cannot. They are wearing a mask, Counselor.
Nor can you determine the person's gender.
You cannot, no.
In fact, the videos don't show a single distinguishing characteristic about the perpetrator besides the general height and build, right?
Besides the height and build that can be matched to the defendant, correct, they do not show anything.
But that general height and build also relates to a very large population of people who aren't the defendant.
Is that a question or a statement, Counselor?
Question, correct?
Are you asking me to speculate, Counselor? Because quite frankly, I'm not an expert witness in the field of demographics. I can speculate if you would like me to, but I do not know how many people have that same general height and build. I can tell you for sure that one of them is, in fact, the defendant.
But there are other people in this world who have a general height and build of Avery Becker.
Yes, there are. However, those people were not part of this investigation.
Thank you. So you don't know that the person in this video is Avery Becker, not with 100% certainty.
From the video alone, you cannot form an entire hypothesis. However, with the other evidence that was provided by Detective Markowitz, you can.
But in regards to this specific video, you cannot tell that this is Avery Becker, can you?
You can't tell who that is in the video, correct?
Thank you.
Consistent with it being Avery Becker.
Thank you. No further questions.
And we'll pause for a moment and then have redirect of Mr. Kuzak. And by the way, we did not admit Exhibit 10, correct? You merely referred to it. Is that correct, Ms. Davies?
That is correct. It has not been admitted previously.
Good enough. And we'll now have redirect of Mr. Kuzak. Mr. Howe.
Before I begin, I would like a quick time check.
Says no time. Is that correct?
I guess, yes.
Okay, so there is no redirect, which means there is no recross. And Mr. Kuzak, you are excused. Thank you very much.
Thank you, Your Honor.
And that concludes the case for the people. We'll pause for a moment and then begin so the scorekeepers can catch up, and then we will begin the defense case with their first witness. And counsel for the defendant, if you'd introduce yourself and your witness.
Good afternoon. My name is Olivia Moraine, and the defense calls Professor Blake Van Owen to the stand.
There we go. And Professor Van Owen, I'll assume you're on the stand. If you would state your name and your actual student name.
Of course, Your Honor. My name is Taylor Davis, but today I'm Blake Van Owen.
And Ms. Van Owen, if you please raise your right hand. Do you solemnly swear or affirm under penalty of law that the testimony you're about to provide today in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
And Ms. Moraine, go right ahead. Your witness.
Good evening, Professor Van Owen. My name is Olivia Moraine, and I'm going to ask you a few questions. To begin, please state your name for the jury.
My name is Blake Van Owen.
And what is your current employment?
Right now, I'm a private investigator.
And do you have any experience in the field of law enforcement?
Yes, I do. I joined the Aurora Police Department a while back, and then I worked as a school resource officer. After that, I went into private security, and now I'm a private investigator.
And have you received any specialized education or training in the field of law enforcement?
I have. I received a master's degree in criminal justice through the Ashford University's online program.
And have you testified as an expert witness before?
Yes, I've testified in over 100 cases, 5 of which are related to cell phone data, which is very relevant to this case today.
And what are your specific areas of expertise?
Well, in addition to my job in education, I consider myself an expert in the areas concerning police practices, use of force, false arrest, and forensic evidence techniques. In that respect, I have been qualified as an expert in the states of Colorado, Arizona, Kansas, Nebraska, and New Mexico.
And have you ever had any adverse issues related to your employment as a police officer?
Yes, there was a civil suit filed against me a while back while I was working with the Aurora Police Department. There was no wrongdoing on my part, however, and although I do feel like I could have handled the situation better, I've grown significantly from that experience.
The defense respectfully requests that the court qualify Blake Van Owen as an expert in the areas of police practice and forensic evidence techniques.
And does the forensic evidence techniques involve cell phones? If you could ask that question.
Professor Van Owen, does your experience in forensic evidence techniques involve cell phone analysis?
Yes.
Good enough. Mr. Howe, any objection to either of those areas for Ms. Van Owen?
Your Honor, prosecution objects to Blake Van Owen being entered as an expert in police practices, as well as cell phone analysis as a part of forensic science.
Do you wish to voir dire?
Yes, Your Honor.
Go right ahead.
Ms. Van Owen, you are being entered today as an expert on police practices, correct?
Yes.
And part of this expertise you are basing off your own experience with the police, isn't that correct?
Yes, I've had years of experience in the police department.
Is it your testimony today that you have had years of experience in the police department?
Say that again, sorry.
Is it your testimony today that you have had years of experience in the police department?
Yes.
You prepared a statement for this case?
Yes, I have.
And you signed this statement, correct?
I did.
Signing that it was truthful,
Yes, that is correct.
accurate,
Yes.
and complete.
Yes.
And you were aware that any time you were able to update this statement, had any new facts come to light?
Yes, that's correct.
And in your statement, you say that you were on the police force for 9 months, isn't that correct?
Yes, but I've had years of experience in the entire, the just criminal justice in general, working with crime.
Was it not your testimony that you have had years of experience in the police department? 'Cause that's what I heard.
I'm sorry, I misspoke.
Thank you. So moving on. And this experience of 9 months with the police occurred over about 15 years ago, isn't that correct?
Yes, that is correct.
Also, with regards to cell phone analysis, you never list any formal training you have had with cell phone technology, correct?
No, but many of the cases that I've worked with have regarded cell phone data.
You also never list any specific education you might have received specifically with regards to cell phone technology, isn't that correct?
That's correct, but once again, I've a lot of
Objection, Your Honor. Relevance.
I'll let Mr. Howe complete his foundation, and then you may substantiate her qualifications afterward. Go ahead, Mr. Howe.
May I re-ask the question?
Yes, you may.
And you have listed no formal education with cell phone analysis. Is that correct?
That is right, but once again, I have a lot of experience in that field.
Your Honor, the prosecution objects to Blake Van Owen being entered as an expert in police practices and cell phone analysis, as she has shown a lack of education and training in this field and experience with regards to police practices.
And Ms. Moraine, let's deal with police practices first.
Your Honor, given Professor Van Owen's extensive experience, expertise, and training in the field of law enforcement and her master's degree in criminal justice, she possesses the necessary knowledge, training, and skill to be qualified as an expert.
And as to police practices, Mr. Howe, do you wish to have the final word on that?
Your Honor, the experience that Ms. Blake Van Owen is basing her testimony on police practices off occurred over 15 years ago and for less than a year.
I'm going to qualify on that issue on police practices. Although her experience may be short, it's still experience, and the jury may weigh that. She has a qualification. The jury can decide whether her practice, whether the practices and procedures in this case convince them, but I'm going to qualify her on police practices and procedure based on her experience. And Ms. Moraine, what about as far as the objection to forensic cell phone investigation?
Well, I wish to qualify Ms. Van Owen as an expert in the area of forensic evidence techniques, for which she has extensive experience and training, and cell phone data analysis does fall under that category.
Mr. Howe?
Your Honor, if she is being entered as an expert in forensic evidence techniques, prosecution asks for a limiting factor that she may not testify as to cell phone analysis.
I am going to qualify her in cell phone analysis because that's where her experience lies, and apparently that's the primary focus of her testimony. Again, you can qualify by training, by education. She did not. She qualified by experience, given the number of cases that she has investigated and the number of times she has been qualified by other courts, quite frankly. So she'll qualify in both areas. If there is a contemporaneous objection to the extent of her knowledge, you may make that as she testifies.
Yes, Your Honor.
Witness is qualified. Ms. Moraine, go right ahead.
Please tell the jury, Ms. Van Owen, about your connection to this particular case.
Of course, I was contacted by the defense to conduct a follow-up investigation. The defense had indicated to me that there appeared to be some evidence that the police department had overlooked.
And were you paid to work on this case?
Yes, of course. This is my job, and like any other job, I'm paid as a professional for my time. I wasn't paid, however, to give any particular opinion.
And what did you do to prepare for this case?
Well, I reviewed the police reports, Kuzak's crime scene reconstruction, the cell tower reports, as well as the exhibits that Markowitz has prepared. I've also conducted my own partial investigation into the missing pieces that were not covered by the police.
I'd like to direct your attention to the part of your investigation that focused on the cell phone analysis. Please explain your findings related to the cell phone data in the investigation.
Well, when I looked into the cell phone data, I found that Avery's phone had, in fact, communicated with a tower near Mackenzie Brackman's house.
And what did this finding indicate to you?
Well, cell towers do not show any exact location where a phone has been, but instead a general radius. So in this case, that means that just because Avery's phone was connected to the tower nearest Brackman's house does not indicate that whoever even had Avery's phone was even close enough to see Mackenzie Brackman's house.
And how did your investigation of the cell towers differ from that of Detective Markowitz?
Well, Markowitz, in my opinion, was not thorough at all. He was very selective in which records he chose to obtain and which records he didn't. It also appeared to me that he was only focused on obtaining records that would incriminate Avery.
And based on your knowledge of the case, which records did Detective Markowitz not obtain?
Well, Detective Markowitz only looked into Avery's phone records, but not any others that could indicate of any other suspects. He also didn't look for data related to Taylor Perkins' phone, which could further corroborate Avery's alibi.
So based on your professional knowledge and expertise, what opinion did you form about the cell phone evidence in this case?
Well, in my opinion, the evidence gathered regarding the cell towers is inconclusive and should not at all be regarded as a vital piece of evidence in this case. Also, the evidence is consistent with Avery's statement that the phone had been stolen.
I'd now like to direct your attention to your investigation of the intrusion into Coach Brackman's home. In your investigation into the intrusion, what did you review?
I reviewed Coach Brackman's autopsy report, the pictures that the police took at Coach Brackman's house, the videos that were downloaded from the Ring doorbell system, and I also took some photos of my own.
What did you take photos of?
The photos I took were a demonstration of how to hold the knife.
I would like to please ask Professor Van Owen to direct her attention to Exhibit 21. Are you familiar with this picture?
Yes, this is the photo I took as part of my investigation.
And is this an accurate representation of the picture that you took?
Yes, it is.
Your Honor, may I please have permission to admit what has been marked as Exhibit 21 to evidence?
Mr. Howe, any objection to 21?
No objection, Your Honor.
21 is in, you may publish.
Your Honor, may I please have my co-counsel share their screen?
Yes.
Co-counsel.
I'm sorry, what exhibit did you need me to publish?
Exhibit 21, please.
21.
Of course, sorry, my apologies.
It's all right, we can move on without publishing it.
All right, if it comes up, you can come back to it.
Thank you, Your Honor. Professor, what does this photo show?
This shows a common way to hold a knife.
And according to your expertise, what is the most common way to hold a knife?
Well, there are grooves on the bottom of the knife that are meant to mirror your fingers for a better grip. And so holding the knife like this with your fingers in those grooves is definitely the most natural way to hold the knife.
And why does the position of the knife matter?
Well, based on my review of the autopsy report, the stab wound found in Coach Brackman's back shows that the knife came from an upward angle. If the knife was being held, how I suspect it's being held, with your fingers in those grooves, the prosecution's explanation of a struggle resulting in the stabbing is inconsistent with the forensic evidence.
How so?
Well, for Coach Brackman to have died during a struggle, as Markowitz has concluded, the victim and the perpetrator must have been facing each other, and the perpetrator would have to reach over Brackman's back to stab him. This would require the perpetrator to be taller than Brackman, which we know Avery is not, and we also know that the intruder in the Ring video camera is not.
So what then, according to your professional knowledge and expertise, do you think happened?
Well, in my professional opinion, and based on my review of the evidence, I believe that it makes far more sense for Coach Brackman to be sitting with the intruder standing behind him, holding the knife, as I suspect, and stabbing him at a downwards angle.
And why does it matter if Coach Brackman is sitting with the intruder standing behind him?
Well, because it negates the prosecution's theory that Coach Brackman surprised Avery and then a struggle ensued.
Thank you, Your Honor. I have no further questions, and I pass this witness for cross-examination.
And in just a moment, we will have cross. Let's let the scorers catch up for just a moment. And Mr. Howe, you may cross-examine.
Good evening, Ms. Van Owen. My name is Abbott Howe. I'll be asking some questions. You have only ever testified as an expert for the defense, isn't that correct?
Right, the prosecution has the police department to testify for them, and the defense does not have those resources.
So is that a yes?
Yes, that's correct.
And you are also being paid to be here today, isn't that correct?
Well, as I said, it is my job, and I'm paid to review the case. I'm paid for my time as a professional, essentially, so yes.
And you agree that you make a good living in this field, isn't that true?
I'm very happy with my job, yes.
But you make a good living, as in amount of money, isn't that correct?
I do okay.
And wouldn't you agree that in order to continue to make a good living in this field, you have to be continually hired by defense attorneys? Isn't that true?
Well, it's important.
Relevance
And Mr. Howe, the relevance of that question?
Your Honor, this is relevant because these questions are pertaining to the witness's potential bias for the defense side, which relates to how biased their testimony is.
Ms. Moraine?
Well, Your Honor, the question was whether Ms. Van Owen is able to make a living based on how many times she's hired in a year, which is not relevant to the content of this case.
I disagree. It is certainly not the foundation for credibility for this witness, but the fact that she's getting paid and that she is paid by defense attorneys, it's relevant. I'll allow it. Overruled. You may proceed, Mr. Howe.
May I re-ask the question?
Yes, you may.
And to continue to make a good living in this field, Ms. Van Owen, you will have to be continually hired by defense attorneys. Isn't that correct?
Well, it's certainly great when there are a lot of defense cases, but I do make money even if I don't testify, even if I do have the same conclusions as the prosecution. So yes, it is good when there are a lot of things for me to do, essentially.
And a defense attorney, you have to agree, would only hire you if you are of some value to them, if you are worth their money. Isn't that correct?
I like to think I'm pretty good at my job. So yes, I hope they do see value in me.
And do you also agree that it is the main goal of the defense today, and as in most trials, to get their client acquitted?
Well, of course, yes.
All right, thank you. Moving on, you did conduct a partial investigation into this case, correct?
I did. I looked into the pieces of evidence that were not covered by the police.
And in this investigation, you never visited the crime scene yourself, did you?
No, I didn't. That was all covered by the prosecution.
Additionally, you never collected any physical evidence, did you?
Physical evidence from the crime scene? No.
You also never conducted any interviews of witnesses, isn't that correct?
I did not.
So in this investigation, you never visited the crime scene, never collected physical evidence, and never interviewed any witnesses, isn't that correct?
I looked into the evidence that was pertinent to the case that the prosecution had overlooked, like the cell phone data. I didn't see any necessity in me interviewing people that had already been interviewed, so no.
So is that a no, that you did not do any of these things in your investigation?
That is a no, yeah.
It is your theory in this case that the murder was premeditated, correct?
Yes.
And it is also your theory that for this to happen, the intruder would have brought in the knife from outside of the house. Isn't that correct?
That is correct. The knife is a different brand as the one at Brackman's house, and so that seems very probable to me.
And you have reviewed the ring video footage for this case?
I have, yes.
And you have to agree there is nowhere in any of the 4 videos where you can see a knife.
Not visibly, but I can assume there are a lot of places that the knife could have been under the clothes of the perpetrator.
But nowhere do you actually see any evidence of where that knife would be, or a physical knife itself. Isn't that correct?
No, I would presume that the perpetrator would not be carrying the knife openly in the neighborhood.
But you also never list anywhere where you believe this knife may have been hidden, correct?
Well, yes, but there are many options or areas where the knife could have been.
It is also your theory of this case that Avery Becker was not at the home of Mackenzie Brackman.
Yes, that's correct.
Because you believe that they were with Taylor Perkins. Isn't that correct?
I think there's many different aspects that corroborate my theory. I think that because Avery said that she lost her phone, that doesn't put her with her phone. I also
you do believe that they were.
Hang on. Let her finish, please. You asked a broad question. She gets to give a broad answer.
I also think that, thank you, Your Honor, sorry. I also think that because the cell phone data is so inaccurate and not at all like a GPS, which we've discussed previously, it's not at all saying that the phone was directly at Brackman's house. Yes.
I was not asking about the phone. I was asking, it is your theory that they were with Taylor Perkins at this time. Is that correct?
Yes, that's correct.
And Taylor Perkins, as you know, is a good friend of the defendant, correct?
Yes, that's my understanding.
And it is only from the defendant and their best friend from which you have this alibi. Is that correct?
That is simply not true. All the evidence also corroborates that theory. The text messages and calls going to Avery's phones that remained unanswered corroborates the idea that the phone had been missing and they were trying to contact it. There are many different aspects that prove my theory.
I'm asking in terms of witnesses, though, these are the only two people that have said anything of this. Is that correct?
Yes, Avery only has one alibi, if that's what you're asking.
All right. Thank you, Your Honor. No further questions.
And we will have redirect of this witness in just a moment. And Ms. Moraine, you may redirect.
Thank you, Your Honor. Ms. Van Owen, does the fact that you yourself were unable to collect physical evidence or visit the crime scene skew your ability to form an evidence-based opinion about this case?
Not at all. That's a very common thing that I do for my job. I often don't collect my own physical evidence from the crime scene.
And what did you use to form your opinion that Avery's alibi was true in this case?
I used many things. I used the cell phone data. I used, of course, Taylor's word. And I also used the witness statements that Taylor was with Avery and that they retraced their steps, and also that they were missing from school that day.
Thank you, Your Honor. No further questions.
And we'll have recross in just a moment. And Mr. Howe, you may recross the witness.
Brief recross. Regarding to the alibi of Avery Becker, you never further investigated into this, such as obtaining cell phone records to verify that they were indeed retracing those steps from the previous day. Isn't that correct?
Well, we do know that they were retracing their steps.
You never further...
Hang on just a minute. I believe that was a direct answer to the question. You may follow up on that, Mr. Howe, if you wish. I cut her. I was going to let her say some more, but I think that she answered the question directly. So you may ask another question or follow up on that answer.
But even though you believe this alibi, you never verified it by collecting cell phone records, did you?
No, but the text messages to me are pretty solidified evidence that that is true.
No further questions, Your Honor.
That concludes Ms. Van Owen's testimony. You are excused.
Thank you, Your Honor.
And we will have the second witness for the defense in just a moment. Let the scorekeepers catch up. And counsel for the defense, who is the attorney and who is your next witness?
Hi, my name is Adele Donda, and the defense would like to call Mr. Taylor Perkins to the stand.
Okay, and we have Ms. Haverkamp going to do the cross. Taylor Perkins is the witness. If you could, I'm assuming you are on the stand, if you would state your name and your actual student name.
My name is Taylor Perkins, and my real name is Tommy McKissick.
Okay. And if you would please, Mr. Perkins, raise your right hand. Do you solemnly swear or affirm under penalty of law that the testimony you're about to provide today in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
And Ms. Donda, you may proceed.
Please introduce yourself to the jury.
Hello, my name is Taylor Perkins.
Mr. Perkins, do you know someone named Avery Becker?
Oh, well, yeah, Avery's my best friend. I love Avery.
Do you also know someone named Alex Cifuentes?
Yeah, I know Alex.
Please tell the jury who Alex is.
Alex was one of our teammates on the mock trial team.
How would you describe Alex's personality?
Well, Alex just has this way of being totally insincere in a passive aggressive kind of way, you know?
Do you know if Alex and Avery knew each other?
Yeah, well, we were all on the mock trial team, so yeah, we all knew each other.
Can you describe the relationship between Avery and Alex?
Well, I knew Avery pretty well enough to know that even though they always seemed fine on the surface, Alex and Avery really never got along at all.
Now, moving on to your mock trial team. Were you on the mock trial team at Colorado High School?
Yeah, I was.
How long have you been on the team?
I was on there for a pretty long time.
Did there come a time when you were no longer on the mock trial team?
Yeah, I ended up quitting the team after Avery got demoted.
Do you know who Mackenzie Brackman was?
Yeah, that was our mock trial coach.
How would you describe the relationship between Mackenzie Brackman and Avery Becker?
Well, I mean, every relationship has its ups and downs, you know, like which one doesn't? But I wouldn't say it was anything crazy.
Can you explain the incident with Avery and Coach Brackman's car?
Well, Avery accidentally used a Sharpie to vandalize Coach Brackman's car, but I know for a fact she thought it was a dry erase marker. And I mean, like, come on, I don't think one mistake like that should fully ruin a person's character.
Now, moving on, did you ever run into the mock trial team outside of school?
Well, yeah, I mean, obviously we all went to the same school together, so I'd see him there. But I remember a specific time on March 5th that was especially bad.
What happened on the evening of March 5th at the Fry Shack?
Well, Avery and I had gone there to get some food, and it ended up being a pretty bad idea because the whole mock trial team went there after practice, and it ended up being pretty awkward.
Can you explain the interaction between Avery and Alex that day?
Well, Avery and I were sitting at her table, and Alex came and sat down, and she was doing her thing of, you know, just like acting like she cared, but I really don't think she did. And it really got to Avery, so much so that Avery ended up actually storming off to the bathroom, and she left her phone behind, which is like so not like her.
What happened after Avery went to the bathroom?
Well, I had to put up with conversation with Alex for a little bit, but after Avery came out, we ended up just leaving.
When was the last time you saw Avery's phone?
Well, it was on the table at the Fry Shack before she stormed off, and after that, I guess I just lost track of it. I don't know.
Did you and Avery look for her phone?
Well, yeah, that next day, we didn't really have anything important going on at school, so Avery and I ended up retracing our steps to try and find the phone. We went to the Fry Shack, we retraced our steps through the mall and went to all the stores we visited there, but we just couldn't find it.
So, can you explain to me a little more? Where were you and Avery on March 6th?
Well, like I said, we were just retracing our steps. So, you know, yeah, we just went to the Fry Shack in the mall, just trying to find the phone.
Was Avery Becker near Mackenzie Brackman's house on the day he was killed?
No, Avery Becker was nowhere near Mackenzie Brackman's house.
Are you sure?
Yes, I'm positive.
How are you sure?
Because she was with me and we weren't anywhere near the house that day.
Now, moving on, do you know someone named Blair Rollins?
Yeah, I know Blair.
How do you know Blair?
Well, she went to the same school as we did.
What do you know about Blair?
Well, everyone that knows Blair knows that she's a little bit off. Like, if I had to guess who was most likely to kill someone in our grade, it would probably be Blair. And she actually hated Brackman too because he lost the case that got Blair's dad sent to jail. And she wasn't even at school that day either. It's kind of sketchy if you ask me, but.
Did Alex and Blair know each other?
Yeah, they were actually really good friends, which is so weird, right?
From what you know, did Alex and Blair have anything in common?
Objection, Your Honor. This calls for speculation.
And Ms. Donda?
Your Honor, this is not speculation, as Mr. Perkins is testifying to his personal knowledge and observations of his classmates, whom he personally knows.
And Ms. Haverkamp?
The witness is speculating as to what went on within that relationship, and that's something they cannot testify to.
I'm going to sustain the objection to that specific question. I will allow you to ask a question about what his perception, what he saw, not what he theorized, but what he saw. If he has an answer to that question, I'll allow it.
So, based on what you know, did Alex hate Mackenzie Brackman?
Well, yeah, based on what I know she did. I mean, I know Alex was always saying that Coach Brackman was overlooking her talents or whatever. So yeah, I think to my knowledge, Alex didn't like Brackman very much.
And to your knowledge, did Blair not like Mackenzie Brackman?
Objection, Your Honor. This also calls for speculation. The witness cannot testify to the emotions within that relationship.
Is Donda?
Your Honor, this is not speculation, as the witness is testifying to his observations of the relationship as he personally knows both.
Again, you'll have to ask the question in that manner, whether or not what his personal observation, factual observations were, not his guess or his guesses about it.
Yes.
You may strike that question and ask a new one.
From what you've observed, how many other people from your mock trial team did not like Coach Brackman?
Well, like I said, I mean, from what I've seen, I know that both Alex and Blair had reasons to not like him. So that's at least 2 other people.
Your Honor, I have no further questions, and I pass the witness for cross-examination.
And we will have cross-examination in just a moment. And Ms. Haverkamp, you may cross your witness.
Good evening, Mr. Perkins. My name is Heidi Haverkamp, and I will be asking you some questions. You were on the mock trial team with Avery Becker?
Yeah, Avery and I were on the mock trial team for a pretty long time, actually. I mean, we always had so much fun together. It kind of felt like we were the dynamic duo a little bit,
And Avery Becker is your friend?
Yeah, I mean, I love Avery. Avery's by far my best friend. I mean, I could talk forever about Avery, but yeah, she's a great person. Love Avery. Yeah, we're really good friends.
And as you said, you two have been really friends for a long time. So you've been friends through the good times?
Yeah, I mean, yeah, like I was saying, I love Avery. She's by far my best friend. I think she's a great person. And yeah, I consider myself very lucky to have known someone like Avery Becker.
And you've been friends with her through the bad times too, isn't that correct?
I mean, well, yeah, what kind of friend would I be if I wasn't, like it's kind of the social contract there to, support my friend when she needs it.
Right. And you love each other, so you help her out like all good friends do.
Yeah, I mean, to a point, like, I wouldn't say I'd do anything super drastic. Like if Avery told me to kill my own mother, no way. But if it's a reasonable request, then yeah, obviously, I don't know why I wouldn't do it.
And do you know what type of relationship that Avery and Mr. Brackman had?
I mean, well, obviously it was a little rocky, but like, every relationship has some ups and downs,
But you always believed that Avery was given a hard time about something.
Well, yeah, I mean, Coach Brackman would get on her back a little bit, but like I said, I never really think it was anything crazy, but yeah, I mean, it was rocky at times.
And that made Avery very upset sometimes. Isn't that correct?
Well, I mean, yeah. Wouldn't it make you upset too?
I'm sorry, was there an objection there? Yes. There was interference when you were both talking, and that's fine. What is the objection?
Speculation.
And Ms. Haverkamp?
The witness has already stated their close relationship with Avery, and they can testify to their knowledge and understanding as to the situation and how Avery reacted.
Ms. Donda?
Mr. Perkins cannot accurately testify to the emotions of Avery Becker.
And what exactly was the question? I must have missed it because I didn't understand it that way. If you just re-ask the question.
I asked if Avery Becker would become upset.
And if Mr. Perkins can testify to his observations, I'll allow him to do that. if that's the question. Mr. Perkins, you may answer that.
Well, yeah, I mean, obviously, if someone's really getting on your back a lot, like, yeah, that can upset you, but like, I don't know. I wouldn't say it was ever anything like too crazy, you know?
Right. But you said that you'd like to help out Avery.
I mean, yeah, I mean, like I said, what kind of friend would I be if I wouldn't help out my best friend, you know? It's
Right.
kind of
And the
like,
way that you're going to help her is by telling the jury you were with her on the day of the murder.
are you insinuating that I'm lying?
No, I'm asking if that's what you're telling the jury, Mr. Perkins.
I mean, I'm telling the jury the truth. I was with Avery Becker on March 6th, and you know, like, I don't know. I mean, I was with her. I don't know what else you want me to say. We went through the mall, we went to the Fry Shack. Like, I'm telling the truth. So,
And you're also going to help out Avery by telling the jury that she may have lost her phone.
well, not may have. She did lose her phone. I mean, I know for a fact that that morning when she picked me up for school, I was like, Avery, why didn't you text me? You normally text me before you pick me up. And that's when we realized she didn't have her phone. So it's not that I think she didn't have her phone. I know she
That's
didn't.
right, Mr. Perkins. She didn't realize that her phone was missing till the next morning. But you claim that Avery lost her phone at the Fry Shack.
Yeah, I mean, like, well, to be fair, I think it's a little fair that she might have been a little flustered, you know? Like Alex had kind of gotten to her
Right,
that night.
right. She was flustered at the Fry Shack, but after that, you two left and went to the mall. Because
Yeah,
the
we
Fry
went to the
Shack,
mall, but like, luckily my
Fry Shack
friend
wasn't the
Avery
last
is.
stop of your night, was it?
I'm sorry, I can you repeat the question? I couldn't hear you.
The Fry Shack was not your last stop for the night, was it?
Well, no, we did go to the mall, but I mean, like, luckily my friend Avery isn't a screenager. She's not, you know, always staring at her phone. So when we're together, I guess she was just focused on me or something. I don't know.
You claim that Avery Becker does not believe that you don't believe that Avery Becker's phone almost never left her hand.
Well, like I said, that's what made it so weird when she left it on the table. I mean, like, she was clearly like feeling very upset. I mean, I don't know.
Right, but you just testified that she's not like a screenager and almost wasn't on her phone when she was with you.
Well, no, I mean, like, how often does your phone leave your pocket? That doesn't mean you're looking at it all the time, you know?
Right, but in your statement, Mr. Perkins, you claim that Avery Becker's phone was like her third kidney, almost
yeah,
never leaving her hands.
Well, yeah, and like I said, that's what made it so weird to me when she left it behind at the Fry Shack.
That's right. It was weird that she left her phone and didn't notice till the next morning.
Well, like I was saying, she seemed very emotionally distraught. I mean, mock trial meant a lot to her, so having to face all those people there, I can't imagine how she must have felt, but it probably wasn't very good.
I have no further questions at this time.
And we'll have redirect in just a moment. And Ms. Donda, you may proceed.
Yes, Your Honor. Mr. Perkins, when was the last time you saw Avery's phone?
Well, like I said, I saw it sitting on the table after Avery went to the bathroom, and then after that, you know, I don't know what happened to it.
Your Honor, I have no further questions.
And we will have recross in just a moment. Very short redirect, so we will have probably a very short recross. Ms. Haverkamp, you may proceed.
Mr. Perkins, you claim that you saw the phone on the table, but you never saw who took that phone. Isn't that correct?
Well, yeah, like I said, I can only tell you when the last time I saw it was, and that was sitting on the table.
Right. You can only
After
tell
that-
me the last time you saw it, not who took it. Isn't that correct?
Sorry, can you repeat that? I couldn't hear you.
You can only tell me when you last saw it, not who took the phone. Isn't that correct?
Well, yeah, I mean, unfortunately, I'm not omnipotent, or this
Thank
case
you.
would
I have
probably.
no further questions.
Thank you. And that concludes Mr. Perkins' testimony. You are excused. And before we have the defendant on the stand, we'll take a short pause so the scoring judges can catch up. And counsel for the defense, if we could have the attorney who's going to examine your client, and we will call him to the stand, her to the stand.
Yes, Your Honor. I call Avery Becker to the stand.
And Ms. Davies is for the defense, and Ms. Sipra will be for the prosecution. And Ms. Becker, if you could state your name and your actual student name.
Yes, my name is Avery Becker, but my name is Millie Bjork.
All right, Ms. Becker, you are the defendant in this case in a criminal matter. You know that you have a right under the Fifth Amendment to the United States Constitution that you do not have to testify against yourself. You have that right, and you understand that. Is that correct?
Yes, I do.
And you are taking the stand, waiving that right with knowledge that you will testify. Is that also correct?
Yes.
If you please raise your right hand. Do you solemnly swear or affirm under penalty of law that the testimony you're about to provide today in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. And Ms. Davies, you may proceed.
Your Honor, before I proceed, may I please have a time check?
Yes.
Thank you. Good evening. Can you please introduce yourself for the jury?
Of course. My name is Avery Becker.
Why are you testifying here today?
I'm testifying because I would like to prove that I did not commit the crime I'm being accused of in this trial.
To start off, I'm going to ask you some personal questions. Were you on the mock trial team at Colorado High School?
I was. I love mock trial. It was one of my most favorite things in high school. I was a part of it for all 4 years. I just love it.
What do you like so much about it?
I would say that my favorite part was getting to spend time with people that I don't normally talk to a lot in school. And I would also say that being a lawyer came pretty naturally to me, which is why I think I was honestly so drawn to mock trial.
Who are some of your friends on the team?
My best friend on the team was Taylor Perkins. We spent so much time together. Taylor and I didn't have a lot of classes together in school, so mock was just the perfect time for the two of us to catch up. You know, we liked hanging out with each other and texting from across the room.
Is there anybody who you didn't get along with on the team?
Well, I would say that I'm fond of most people on my team, but if I'm being honest, there was always something off between Alex Cifuentes and me. It wasn't that we didn't get along, but it rather seemed that Alex was jealous of my natural mock trial abilities.
Can you please further explain Alex's jealousy?
Sure. So, as I said, I do have quite an aptitude for mock trial. I could examine anyone without really preparing, and that bothered Alex. I also did miss practice a few times, and I think this particularly annoyed Alex since mock trial did come so easily to me, and Alex worked really hard at it. I even won a Best Attorney Award at regionals.
Now turning to Coach Brackman, did you ever have any differences with him?
With every relationship, there are ups and there are downs. Similarly to Alex, it bothered Coach Brackman that I did miss practice a few times. But deep down, Coach Brackman knew that I had an instinct for mock trial. And when I found out that Coach Brackman had been murdered, I was devastated.
Were you involved in an incident with Coach Brackman's car?
Yes, I was.
Okay, please explain this incident for the jury.
So, before regionals, Coach Brackman moved me down to B team for a while because he claimed that I was never prepared and never practiced, but then he moved me back up. Then at regionals, I won Best Attorney Award and even Best Closer Award. After the tournament, Coach Brackman said that I didn't deserve the award and that I was going to make the team look bad at state. He said I was just, I think, relying on my good looks and that I was just lucky.
And what happened next?
I was really, really angry. I stormed out of mock trial practice and I had a whiteboard marker in my hand, which I later learned was a permanent marker. I took said marker and drew all over Coach Brackman's car. I thought it was a dry erase marker. I would never intentionally draw on his car with permanent marker, no matter how mad I was. I knew it was his most prized possession. I thought it would wash right off. Anyway, after that, Coach Brackman kicked me off the team.
Did you ever try to apologize to him?
Of course. The next day I went to his office, but his secretary said he was busy and
couldn't talk to me. I sent him a text message. I told him how sorry I was and that I would try and clean the car myself or get a summer job to make money to get the car repainted, anything to fix this horrible mistake that I had made. But Coach Brackman never responded, so I never got the chance to apologize to him before he died.
He never responded. Let's move to the day that Coach Brackman was killed. Do you remember where you were that day?
Yes, I do. I remember it clearly. The day before, March 5th, I was with Taylor at the Fry Shack in the mall. But I'd lost my phone, so on March 6th, I went to Taylor's house and we decided to skip school to look for my phone since neither of us had really anything important to do that day. Taylor and I were together the whole day. We retraced our steps at the Fry Shack and then, of course, at the mall, and kept using Tay's phone to call mine, but it never picked up, so I just figured it was dead or even stolen.
Is there any time during that day that you were not with Taylor?
No. Like I said, we spent the whole day retracing our steps together to try and find my phone from the day before.
Where do you think your phone was?
Objection, Your Honor, speculation.
Ms. Davies?
Your Honor, my client is allowed to testify to her beliefs and personal opinions of the matter.
But she has to have a factual foundation for an answer. And if she has one, she has to indicate what that factual foundation is. If she just doesn't know, she has to say that, but she can't speculate without a factual foundation. So if you can ask her, if the first question I will allow you to ask is whether she has any specific factual basis as to where her phone was. If she doesn't have one, she cannot then state an answer because it would be speculation. If she can say, yes, I have a specific fact that I can rely on, even though if it's a tiny little fact, but you have to ask that question first or I won't allow it.
Thank you, Your Honor. Do you have a specific fact that relates to where you left your phone?
Well, at the Fry Shack, we were playing video games on our phones and I had to go to the bathroom. So I left my phone at the table with a bunch of people from my school who were there.
Thank you. Can you please, why do you think that, sorry, never mind. Can you please look at what has been previously admitted as Exhibit 14?
Yes, I can.
Remind us, what does the time say on the text messages?
It doesn't look like there's a time attached to these messages.
Did you send these messages?
Absolutely not. Like I stated earlier, my phone was missing, so I could have never texted Alex without it, and I think Alex took my phone.
Moving on, you earlier mentioned Blair Rollins. Who is this?
Blair Rollins is another student at Colorado High School. Blair and Alex were close friends, but I never talked to Blair much. However, I do know that Blair did not like Coach Brackman.
Why is this the case?
Coach Brackman lost Blair's father's case, which ultimately sent Mr. Rollins to jail.
Interesting. Avery, can you describe Blair's physical appearance?
Blair and I have a similar build and a similar height.
Finally, did you kill Coach Brackman?
Absolutely not. The only thing I did was damage Coach Brackman's car, and I shouldn't have done that. I did not kill Coach Brackman, and I just can't even believe that I'm being accused of this.
Thank you. No further questions.
We'll have cross-examination of the defendant in just a moment. And Ms. Cipra, you may cross-examine.
Yes, Your Honor. Good evening, Ms. Becker. My name is Taylor Cipra. Let's talk about your mock trial team. Mackenzie Brackman was your mock trial coach, correct?
Yes, he was.
Alex Fuentes was on your mock trial team.
Yes.
And as was Taylor Perkins.
Taylor was on the team with me.
Now, Coach Brackman told you that you were lazy.
I think Coach Brackman was honestly just jealous that I could do things on the fly because
Ms. Fuentes, so hard. Ms. Becker, I'm not asking why.
You asked a broad question there, and I'm going to allow Ms. Becker to answer. You may finish your answer.
Yes, Your Honor.
So Coach Brackman worked really hard to become the lawyer he was, and I really do respect that. But since mock trial came so easily to me, it might have come across as lazy, that I didn't need to prepare as much as he may have needed to.
He never gave you credit for anything that you did.
That goes really similarly to what I just said. He didn't really realize that I was able to do things so well without preparing.
Thank you, Ms. Becker. He would also rewrite all of your hard work and all of your drafts.
Yes.
He would always criticize your work.
Like I said, I think it was honestly just because he was jealous and he tried to make it seem like he was better of a lawyer than me.
And I will allow you to cut her off because she answered the question and now is wandering into a different area. So you may ask a new question.
You two would both argue at every practice or almost every practice.
We would get into the occasional argument, nothing too crazy.
And as a result of all of this, Coach Brackman bumped you down to B team. Isn't that right?
Yes, he did.
You tried everything that first time to convince Mr. Brackman to let you back on A team, didn't you?
I mean, I knew that the team needed me, and I knew that we would not be able to succeed at state without me on the team. So I was really hoping to get back on A team.
Thank you, Ms. Becker. But your efforts failed that first time, didn't they?
Yes.
Now, you knew that your best friend, Taylor Perkins, felt bad for you and your team, didn't she?
I think that Taylor just knew that in order for A team to succeed, they needed me on the team. And Taylor also knew that mock trial was much more important to me. Taylor honestly just joined it to be with me.
Thank you, Ms. Becker. And you knew Taylor Perkins felt that A team would never win without you.
Exactly, yes, because Taylor knew that I was a really strong member of the team.
Thank you, Ms. Becker. A week before regionals, your friend Taylor Perkins quit the A team.
Yes.
So Coach Bracken had no choice but to put you back on A team.
Since I was the person that really needed to be on the team, yes, that's the case.
Thank you. But once you were back on A team after regionals, your practices just were the same, weren't they?
Yes.
He criticized your work.
I mean, Coach Brackman always did that. It was just kind of a thing we had.
Right, he kept doing that even after you were back on A team.
Well, I mean, I'm guessing he wasn't happy about the fact that I had to be moved back up to A team, so.
Thank you, Ms. Becker. Coach Brackman told you that you didn't deserve Best Attorney Award.
He said I was just relying on my good looks and that I was lucky, but deep down, he knew that I was really the best lawyer.
Thank you, Ms. Becker. Coach Brackman told you that your closing was just lucky.
Yes.
And that you wouldn't fare well at state.
That is correct.
Which made you really angry, didn't it?
I was really frustrated because I love mock trial and I wanted to do everything to make the team be as good as we could be.
And also angry?
I mean, yes, it made me angry, like I said in my direct.
Right, you were angry enough to storm out of practice that night.
I was.
With a Sharpie in your hand.
I thought it was a dry erase marker. I would never intentionally do this.
Right, you thought it was a dry erase marker, but it wasn't, was it?
I thought it would wash right off.
Right. And you wrote Worst Attorney Award on his car, vandalizing it.
Yes, I did, and I regret it so deeply.
Right, but you did do it.
I did.
And so Coach Brackman promptly kicked you off the mock trial team for good, didn't he?
Understandably, what I did was horrible.
Which made you even madder.
Yes, it made me angry that I could no longer be a part of mock trial.
Right, because mock trial was your whole entire life.
I love mock trial, yes.
And you vowed to yourself that you would get back at him if it was the last thing that you did.
It wouldn't I did say that, but it wouldn't necessarily mean that I would get back at Coach Brackman. I just wanted to have my last chance to be on mock trial. I was a senior and I needed everything.
Ms. Becker, so you're saying you would not get back at Coach Brackman?
I know I said that, but it's not at all what you think. I just wanted to be back at mock trial.
Right. No further questions, Your Honor.
And we will have redirect in just a moment. Ms. Davies, you may redirect your client.
Thank you. Do you consider yourself friends with Alex?
Alex and I have never been friends.
How is Blair's relationship with Coach Brackman?
Objection, Your Honor. This is not within the scope of my cross.
And Ms. Davies?
This is proving the relation, the alternate suspects and the relation of other people that went to Miss Becker's school.
Response, Your Honor.
Ms. Cipra?
I did not specifically talk about Blair Rollins, so that cannot be addressed in redirect, as that was not addressed in my cross.
I agree. Let's have another question.
I'll move on, Your Honor. Thank you. Did you like Coach Brackman?
In fairness, despite Coach Brackman's massive ego, he brought our mock trial team to a great place. We were competitive, we were at the top, and I genuinely loved Mackenzie Brackman, maybe in a less obvious kind of way. And I honestly just can't even believe that this has all come to this.
And finally, why do you love mock trial so much?
Mock trial, it came pretty easily to me. It was everything I loved about high school, one of my most favorite aspects. And I loved the rush of just being in the courtroom and being able to cross-examine anyone, do a closing. I love mock trial.
Thank you. No further questions.
And we'll have recross in just a moment. And Ms. Cipra, you may have recross on the defendant.
Yes, Your Honor. Ms. Becker, you just testified that you love mock trial, correct?
Of course.
And would you say that it's your whole life?
Yeah.
But wasn't it taken away from you?
Yes, mock trial was taken away from me.
And that made you very upset and angry, didn't it?
Yes, I was really upset that I could no longer do mock trial.
No further questions, Your Honor.
And I don't know what that noise was, but that concludes the testimony of the defendant and the witnesses in the case. And Ms. Becker, you are excused. You may return to counsel table. And in just a moment, we will have a closing argument for the prosecution. Who will be doing closing?
That would be me, Your Honor.
And Ms. Haverkamp, do you wish to reserve any time in closing for your rebuttal?
Yes, Your Honor.
Specific amount. So when do you wish to be notified by the timekeeper?
Preferably every 30 seconds towards the end.
So like within a minute or within 2 minutes, you want 30 seconds?
Within 2 minutes, please.
Okay, within 2 minutes, we'll have 30-second notice, and any additional time will be reserved for rebuttal. Will that work for counsel for the defendant?
Yes, Your Honor. Thank you.
Okay, good. And we'll just a moment while the scorekeepers catch up here. That being the last witness. We'll now have a closing argument from the prosecution. Ms. Haverkamp.
We've all had a moment in our lives when we made a choice, yet we didn't choose the consequences. For example, despite the Colorado fire bans of these past years, people have still made the choice to start fires. When a spark gets out of control, the result is a raging forest fire. It doesn't matter what you intend at the start, you are still responsible for the outcome. And that is exactly what this case is all about. When on March 6, 2020, in Colorado, Avery Becker broke into Mackenzie Brackman's home to commit criminal mischief and in the ensuing struggle, killed Mackenzie Brackman. The burden of proof in this case rests on the prosecution, meaning that we have to prove to you beyond a reasonable doubt that Avery Becker is in fact guilty. Reasonable doubt is the highest standard of proof, but it is not impossible to reach. Reasonable doubt is a doubt that is not a vague or a speculative doubt. Today, the prosecution has to prove that Avery Becker unlawfully entered the residence to commit criminal mischief, and we also have to prove that in the progression of this crime, the defendant killed Mackenzie Brackman. Today, we reached our burden with the use of the objective evidence. Today, you saw the call detail records, the text messages, and you heard the testimony of 3 reliable witnesses. Avery Becker sent a string of messages clearly expressing her intent to trash Brackman's home. Today, you saw those same messages that show Avery's already established plan to commit criminal mischief. You heard from multiple witnesses of the defendant's prior disregard for the law and of her rash and volatile nature. The defendant claims to be nowhere near the scene of the crime, but today you saw the call detail records. Cell towers place Avery Becker's phone at her own house and track her along the fastest route to the scene of the crime. Not only that, but the call detail records place Avery Becker there at the time that Mackenzie Brackman was murdered. Avery Becker has both the motive and the opportunity. The defense's entire theory of the case is based off of biased and untrustworthy witnesses. Blake Van Owen, an expert who has always only testified for the defense and who's being paid a large sum of money for their testimony here today, is what the defense is relying on for the basis of their incomplete investigation. It also happens that the only person who can testify to Avery's whereabouts for the day of the murder is the defendant's very own best friend, who is more than willing to do anything for Avery. You cannot rely on Becker's self-serving lies and excuses, because today we have reached our burden. There is no doubt that Avery Becker is the one who wielded the knife. Hold Avery Becker accountable, because we are responsible for all of our choices. And Avery Becker is responsible for the spark that started this fire.
Thank you. And we will have a closing argument for the defendant in just a moment. And Ms. Davies, for the defendant, you may close.
Thank you, Your Honor. The prosecution must prove beyond a reasonable doubt that Avery Becker murdered Mackenzie Brackman. The prosecution failed to meet this burden due to several key facts. First, the investigation was rushed and sloppy, and no other suspects were considered for the case. Second, Avery was not at the crime scene and has an alibi, which Taylor Perkins can support. And finally, and most importantly, the evidence in this case points to 2 alternate suspects, Alex Cifuentes and Blair Rollins. The prosecution tried to convince you that Avery Becker murdered Mackenzie Brackman because she was demoted to B team. But Alex and Blair are the individuals who have motives. Alex desired to become a mock trial star, and Blair's desire to kill Coach Brackman to get revenge for losing the case that sent Blair's father to jail. First, the prosecution's key expert witness, Detective Markowitz, clearly rushed the investigation. Miss Van Owen told you that, that Detective Markowitz jumped to conclusions with the knife and the cell phone tower data and never considered other suspects. In addition, Detective Markowitz ignored the fact that there is no physical evidence that connects Avery Becker to the crime scene. No footprints, no DNA, nothing. You can't even tell who the assailant is in the Ring video. Second, Avery Becker was nowhere near Coach Brackman's house on the day of the murder. Taylor Perkins, Avery's best friend, testified that Avery lost her phone the day before the murder and that he and Avery were together the day of the murder, that is, looking for her phone the entire day. In addition, Mr. Perkins explained that he and Avery were nowhere near Coach Brackman's house when looking for the lost phone. Ms. Becker can support Mr. Perkins' testimony, as she explained she did lose her phone. And she also explained that the text messages that Alex claims to have received from her are fake because she didn't have her phone to send them. Third, Alex Cifuentes has a dream and a plan. As Avery Becker testified, Alex was jealous of Avery and wanted to get her out of the way. Alex went to every trial and prepared for every trial and went to every practice. However, none of this dedication or work allowed Alex to outshine Avery in competition. This is because Avery is an accomplished individual who has incredible mock trial abilities. Imagine how frustrated Alex must have felt, working as hard as possible, but never being able to outshine Avery. Meanwhile, Blair Rollins has a reason to despise Coach Brackman. Coach Brackman lost the case that sent Blair's father to jail. This makes it easy to see why Blair wanted revenge against Coach Brackman. Alex had a dream and a plan and used Blair's desire for revenge in order to accomplish it. As Alex wanted Avery to go to jail and Blair wanted revenge against Coach Brackman. This would be the perfect crime, as it would ruin both the lives of Avery Becker and Mackenzie Brackman. Members of the jury, the prosecution did not meet the burden of proof. Not only did the prosecution shortchange the investigation, but Avery Becker was not at the crime scene and has an alibi which can be supported by Taylor Perkins. And most importantly, there are two alternate suspects that the evidence in this case points to: Alex Cifuentes and Blair Rollins, who both have clear motives to kill Coach Brackman. I ask you to find the defendant not guilty.
Thank you. And we will have a rebuttal from Ms. Haverkamp in just a moment. Can we have a time check on the rebuttal? Oops. Minute and a half. Ms. Haverkamp, your rebuttal argument in closing.
The defense has tried to convince you that Alex Cifuentes is the true murderer in this case. But Avery Becker is the only one here today with the opportunity. She is the only one here today who has the motive. Thank you.
Thank you. And that concludes the trial for today. What we'll do now is the scoring judges are working on their electronic scoring sheets. Each of you of the jurors, the scoring judges, if you would activate your video as soon as you have submitted your scoring sheet. That way I'll know that you've submitted it, and then we can proceed to any comments you have. In the meantime, I'll be quite generic here. Although generic comment, I've got a couple of specific things, but we've got a tremendous trial here, quite honestly. Your witnesses were outstanding, every single one of you, absolutely outstanding. You knew your facts cold, you could respond to cross-examination, great animation in what you were saying, every one of you, all six of you, really outstanding. I had all of you as well, witnesses included, but primarily the counsel, great eye contact with the camera here. It's very hard. These are just terrible circumstances to do this under. This is why we don't do jury trials virtually. We can have court trials virtually, but not jury trials. And eye contact is a big part of a jury trial. And you have a great temptation to look at your notes, all of you, because it is virtual. You don't have people in front of you, but all of you did extraordinarily well. And the times when you did use notes was very discreet. It wasn't as if you were reading, it was more as if you were just refreshing your recollection about the next point or the next question, all done very, very well. Let's see, I've got 2 of my 3 judges done. The other comment I had was you can prepare for objections. That's part of what you do. And Ms. Young has joined us. Let me finish up on my comment. You can prepare for the objection, which is part of your preparation in mock trial. What you can't prepare for is what the judge is going to ask you. So as to any particular objection, you can't prepare for the judge. So make sure you are listening very carefully to what the judge is asking and respond directly to that. Because if the judge says it, there's a reason for it as to why the judge is asking that question. That's what you need to answer, not what you may have prepared for, but what the judge asked for. So I'm hoping that all the folks at home that are listening to this on YouTube will give you the same round of applause that we give you. It's a great job. And I'll ask Ms. Young, do you have any comments?
I thought everybody did really well. I was really impressed with how well they spoke, their and their confidence in their words and the diction and their expressions and how they presented it. So that was really exciting to see, and because it's rare to see teenagers and a lot of adults speak so well. And so even if you don't become an attorney, that's going to do you so much good in any profession that you go into. You're going to be very well spoken and be able to do presentations and probably be a top executive in your companies wherever you go and what you do. So yeah, I thought you definitely knew the case and answered the judge's questions very well. So you should be very proud of yourselves.
And Ms. Judge, any comments? Whoop, you're muted there.
There we go. Yeah, great job, you guys. I think you all did very, very well. This is one of the first times I've done volunteering for mock trials for 3 years now, and this is one of the first times I've actually seen both teams slow down and actually think about what they're saying. You guys did a very, very great job of articulating what you were trying to get across. Even when you got a little stumbled or when the judge threw something at you that you weren't quite sure about, you still stopped and took a minute to really consider what you were going to say, which is really important, especially when you've got, a jury that's trying to listen to you and trying to understand exactly what's going on. We rely on you guys to help us with that. So great job on that. It's also really hard. I commend all of you for switching gears and being able to do this virtually. It's really hard to do something of this caliber, especially when you're trying to get your thoughts out and you're talking over each other. It just happens when you're on, on virtual, meetings anyways. So, definitely one piece of advice would be just to, if you do hear someone talking over, just try to stop and listen. Because there was some times when maybe I missed a fact or I missed an argument because you were talking over each other, but I do also recognize that this is one of those platforms that it's really hard not to do that. So in general, you did a really, really great job. The performance was very well done. So congrats and the best of luck to all of you.
And from the most knowledgeable and experienced person on this entire conference, Magistrate Ryan.
Probably not, but thank you. I just want to say to everybody, you guys are just awesome. To be able to do this virtually, I don't know if I could practice as an attorney doing things virtually. It is a different world. It is a different experience, particularly when you're trying to present to a jury. There is a different emotional thing that you can't necessarily connect with virtually that misses a little bit. And you all did a really good job of just transitioning into this virtual environment. And I want to commend you for that. It's difficult. And again, I don't know that I could have necessarily done that. So I'm glad I'm not in private practice anymore. What I'm going to say about just quickly, because it's almost 9 o'clock, you guys got to get up early tomorrow and do this all over again for 2 more rounds. is one thing on experts. I would encourage you folks to remember weight, not admissibility. Memorize that. Weight, not admissibility. If you are fighting for something that certainly comes in under 702 because there's just a tidbit of experience or a tidbit of something else, if you're defending it, weight, not admissibility. And if you're fighting to keep it out, question whether or not you're losing face in front of somebody, because if you're fighting for something that really there's at least a little bit there, hammer home to the jury that it's weight. The weight of this testimony isn't very good. Don't fight for things that shouldn't be fought for. The other thing that I might say in terms of the attorneys, you all did a great job with your signposting. Your coaches and everybody that is sitting in the background that we can't see right now because we're in this virtual environment, great job, because I'm hearing those things that I just love to hear. Very good signposting. There were some legal things going on there. I'm like, wow, these guys are really great. So I know that there's a lot going on in the background. Witnesses, very believable witnesses today. You guys did a great job of not fighting bad facts. When you had a bad thing come out in cross-examination, you just let it go. Great job with that. So good job. Good luck in the next 2 rounds. I don't want to take too much of your time since it's almost 9 o'clock and you got to get up tomorrow morning. So thank you, everybody. Great job.
And thank you all very much. This is really like trial, and we have gone much later than we ever expected. But that's what's going to happen in trial. You will not go to bed for the next day if you're in trial. You will be up and you will get up early. So that's what's going to happen tomorrow. Good luck to all of you. And for our Arapahoe County, all of you participants can drop out. I don't know, do we go back to the waiting room or the lounge, as they call it, or are we done?
They told us to go straight back or just leave.
Tours have been confirmed, and everyone is good to go now. Thank you.
Have a good weekend.
Thank you so much.
Thank you so much for doing
Thank
it.
you.
Thank you.
Thank you.
Have a great
Thank
night.
you.
Thank you.